though you're muted. There we go.
Sorry.
No, that's
So
okay.
does that
First of all,
mean that we have to come back to court again?
Not if we enter the judgment, I don't think.
If a judgment-
To file the paperwork.
yes. So your answer should be no, given that everything is signed.
Okay.
All right, ma'am? Okay,
Okay,
thank you.
Thank you. Everybody have a great day. I just hang up.
Yes, ma'am.
Okay, bye.
Shavella Knight.
Okay, can you hear me now?
Yes, I can hear you now.
Okay, thank you. This is Shavella Knight.
Okay, I'm just waiting for the plaintiff's attorney to check in the meantime, I'm going to place you into a breakout room, and then as soon as they get here, they'll be in to speak with you, okay?
Okay, thank you so much.
You're welcome.
As Zoom user, are you Dylan Smith?
I am.
All right, you should remember from last time, I'm going to ask you to take your hat off if you would.
Yep.
Good morning, everybody. It is Monday. Feels like Monday. Last Friday felt like Monday.
Yeah.
All right, we've got several matters to address. Our first matter is CNH Capital, Industrial Capital America versus Dylan Smith. Mr. A. Solomon Leroyer is here on behalf of the plaintiff, and Dylan Smith is here. We had tried to have a pretrial on November 10th, and I was looking at my notes. I couldn't remember exactly what happened. We started the pretrial at 8:30. No one showed up for the plaintiff. We made quite a bit of a record, and the plaintiff didn't appear. Then I either called him or he showed up late. And then Mr. Leroyer and Mr. Smith had never talked to each other, had no discussion about settlement of the matter. So we agreed to give the defendant, Mr. Leroyer's telephone, contact number, and email, and we continued the matter until this morning. I'll defer to you, Mr. Leroyer. What's the status here today?
Good morning, Your Honor, and Happy New Year to you.
Thank you.
So, yeah, I had some discussion with Mr. Smith, and myself have been having some discussions. In fact, we're pretty close to a settlement on this matter. Mr. Smith advised me that he's been in and out of the hospital because his wife is due to give birth any time from now, which is very understandable. So we're very close to settlement. We're just trying to finalize the settlement terms. I'm speaking with my clients to discuss the terms, and Mr. Smith has already made a proposal. I'm just in the process of discussing that with my client, and the holidays kind of made things a little bit delayed. At this point, I would ask, and I and Mr. Smith did discuss on Friday actually, and we propose adjourning this pretrial one more time for about 4 weeks. And here's why. We're very close to a settlement. I don't think that we're going to need that pretrial. It's just to give us additional time to finalize the settlement terms. And once that's done, we'll enter a stipulated order of dismissal. I just have to discuss more information with my client regarding Mr. Smith's proposal, and then we would finalize the settlement agreement, have that executed, and then we'll be able to enter the dismissal order. But I also informed Mr. Smith that if we're unable to come to a settlement, then we would have to appear before you again. But I'm positive we should reach a settlement before the next scheduled pre-trial, about 4 to 6 weeks from now.
First you said 4 weeks, then 6. Maybe we'll split the difference. Mr. Smith, did you hear everything Mr. Loy said?
Yes, I did.
Did you have a chance to talk to him, I guess, last week?
Yeah, we had spoken at the end of last week, and we're on the same page with everything. So
are you okay with adjourning this a little bit?
Yep.
All right, well, let's try it again. The world isn't going to come to an end if we don't resolve this. Let's see what we got.
How's this?
I'm going to be gone a couple Mondays in February, but how about if we adjourn this to 9:30 on February 9th? Does that work?
That should work for me, Your Honor.
it works for me.
Sort of crammed it in there, but I'll note expect settlement. Yeah, our last pretrial was November 10th. We had Thanksgiving, Christmas, and New Year's in the meantime. Now we're through with all of those holiday issues. So let's see if we can resolve this by February 9th. If we do, great. If we don't, we'll have a pretrial and see what we need to do to resolve it, either try it or have a motion for summary disposition. All right, it is quite a bit of money. I think it's like $16,000. So it's a fairly large by district court standards case. But you guys have got about 5 weeks or 4 weeks to discuss this, and we'll see how we're doing on February the 9th.
Thank
All
you, Your
right,
Honor.
thank you. Both good to go.
Thank you, Judge. Have a good week.
All right, thank you. Mr. Lemunion, could you join us?
Yep, I'm here. 1 second. I'm trying to get the thing to unmute my video.
Mr. Sefton, are you here on Midland Credit?
Yes, Sharon.
Very good. Good morning.
Good morning. I'm a little confused because the information they sent me, it looks like this is a pretrial. And what they sent me was a motion for summary disposition, which I don't even know is on the court's calendar. So the court.
Well, it is a pretrial. Let me look. And a motion for summary disposition.
Okay.
Yeah, they're both set for this morning.
All right.
Summary with pretrial. All right, Mr. Lemunion, good morning. Can you hear me?
Yep, I can hear you fine.
This is file number 251520GC. Stands for General Civil. Attorney Michael Sefton is here from Midland Credit Management, who is the plaintiff, and the defendant is Justin Lemunion. P31320. It's a claim for $906.97. The lawsuit was filed. The defendant filed an answer. Did a pretty good job, just a general denial of the claim. In the meantime, the plaintiff filed a motion for summary disposition with extensive documentation showing the credit history on this credit card. Mr. Lemunion?
Yes.
Lay people are not familiar really with the concept of summary disposition. When you get served with a lawsuit it says right on the front, you are being sued. You have 21 days to file a response to this lawsuit, and you did that. You filed a response, which gets you past a default. If you don't answer the complaint, you get defaulted, and that happens very, very often. So you filed an answer, and it got set for this. Plaintiff filed this motion for summary disposition. You got a copy of it, but what it says is there is no material issue of fact. You haven't stated a defense. You give a general denial in your answer, but that gets you past default, but it doesn't necessarily get you past a motion for summary disposition. Mr. Sefton, do you have anything further to say other than what's in the complaint and in the motion?
No, Your Honor. If you'd like to set up a payment plan, so they don't have to chase him down or garnish his wages, a small amount, you could probably.
Well, let's talk about that. If I do grant the motion, Mr. Lemunion, the damages they seek are $906.37 plus costs of $118.30. So the total debt would be $1,024.67. Mr. Sefton is willing to try to set up some sort of payment plan where you could pay in installments to resolve that. Are you willing to discuss that?
I am. The amount though is the problem that I'm having. Because there was a lot of that. I owed like $400 on the account, and then they just started racking up late fees. And when I tried to pay it, they wouldn't accept my auto payment. But yeah, we could work out a payment plan. That's fine.
All right. Well, you didn't say any of that in your answer. You just filed a general denial. So I'm going to put you guys in. I'm inclined to grant the motion. You raised the defense now, just orally, that you never pled. But that's what happens. There's late fees and overage fees, and the debt grows, and then all of a sudden you have a $300 credit limit, but you owe $1,000. I'm going to put you in a breakout room where you can discuss this privately and discuss a payment plan. I'll be right here thinking about deep thoughts. So click the button that says join, and I'll be here.
Thank you.
All right, so I've got a 9:30 and a 9:45. I had a 10, but that resolved. I had an 8:30 that resolved and a 10 that resolved. So after 9:45, we'll take a break and we'll come back for sentencings at 10:30. Turn to the matter of Midland Credit Management versus Justin Lemunion. Parties have been in a breakout room, had an opportunity to discuss the matter. Mr. Sefton, what's the status here?
We're going to go ahead and allow the entry of the summary disposition. However, he has made a proposal. He's given me a cash proposal, which I will have to send on because it doesn't fit within the guidelines of my ability to settle. But most of these companies, they will come to some kind of an agreement and get the thing resolved fairly quickly. So we have to keep coming back to court to collect this over the
All
next.
right, I will put in here, parties will continue to discuss the settlement. I find that there is no material issue of fact and the defendant has not stated any defense in his general denial. He did raise a defense today, but he didn't respond to the motion for summary disposition and hasn't stated any pled defense. Mr. Lemunion, you did about as well as most lay people do. This isn't a huge debt. It's $906. This is something that may be resolved. But I find that summary disposition for the plaintiff amount of $1,024.67. I will note in here parties will continue to discuss settlement.
Thank you. Mr. Lemunion was very polite and very easy to work with, Your Honor, and I appreciate the consideration because a lot of people get mad at the messenger and of course at the court, but that's why the court gets the big bucks and we get the little ones. Yeah, right.
$9 an hour works out either way. All right, Mr. Lemunion, are you still at US 12?
Yep.
Is there a lot number?
No.
That's a house?
Yeah.
Okay, we'll send you that. The contact information is there. Mr. Sefton will go back up the line to Middleton Credit Management and see if your cash offer would resolve the case. Do you have any questions?
Nope, not that I can think of. Yeah, like.
All right, well, you're
Yep, that's
good
it.
to go on about your day and they'll be in contact with you to discuss your proposed offer.
Okay.
Thank you, sir. Thank you for being here a little early too. We got done a little early.
Thank you.
All right, thank you. Okay,
Thank you, Your Honor.
Mr. Sefton, I'll see you again.
Probably.
Yes, probably. I'll be here for a while yet.
All right.
Good morning, Mr. Conley.
Good morning. Happy New Year.
You too. Mr. Love is here in the waiting room.
I have not had a chance to speak with him, Your Honor, as of yet.
Yeah, I thought I'd put you guys in a breakout room. I just did in the last case and we mostly resolved it.
Thank you.
We're actually about 10 minutes early. There's no harm in that. Mr. Love, could you hear me? Good morning, Mr. Love. Can you hear me?
Yes, sir.
There you are. Good morning, sir.
Good morning.
This is file number 251568GC. It's entitled Three Rivers Health versus Jonathan Love. Mr. Robert Conley is here for the hospital and Jonathan Love is here by Zoom. Well, the Lions won last night, but it kind of didn't matter at this point. I don't know if that's a Lions jersey you got on or somebody else, but
It is, sir.
all right, kind of blew it a little earlier in the season. Anyway, this is a claim for $5,268.97 for services rendered at Three Rivers Hospital. Mr. Love was served with that lawsuit and he wrote a note. We accepted it as an answer. And he said, these are my daughter's medical bills. She didn't have my permission and I never gave permission to her to be seen. She never had any services done to my knowledge. As often with these medical claims, you can't really tell what they are. The complaint was filed in July and it lists dates of service. You can't even tell when they were. I don't like these bare bones pleadings, but they are legal. They allege that you owe 1, 2, 3, 4, 5, 6. I can't tell what the dates of service were or what they were for. So it's very hard to respond to a lawsuit like that. I don't know who the patient was, what the dates were, what the service that was given, and neither do you from what you're looking at. So Mr. Conley is here and he's willing to meet with you privately in a breakout room to discuss this. See exactly what we got here. Are you agreeable to that?
Yes, I'm lost in the water too. I have no idea these services.
All right, well, let me put you guys both in breakout room 1. Hit the button that says join and you should be good to go.
You can admit or deny or admit with an explanation.
I admit.
As to the plate citation, Officer Cole, is there anything you want to add?
Motion to dismiss the expired plates.
Do you pronounce your name Slyman or Sleeman?
Slayman.
Slayman.
Yeah.
The expired plate citation is dismissed thanks to the officer's motion.
Thank you, officer.
And the unsafe start does not carry points, but it does carry a fine of $175, which can be paid online or by mail or at the courthouse counter. You can clear that online or by mail.
All right.
Thank you.
Thank you.
And we have Noah Prince.
Good afternoon.
Good afternoon. Actually, good morning still.
Sorry.
Not a bad problem. This is 25 RO 07679. This is a ticket that was issued on the 2nd of December of 6:10 in the morning. Here in Royal Oak near Greenfield and 13 Mile Road. You were cited for failing to stop in the assured clear distance ahead. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Admit responsibility.
Deny.
Deny responsibility.
You are denying responsibility? Okay. Raise
Yes.
your right hands, please. Please raise your right hand.
Right.
Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Yes.
The officer will testify first, please.
Your Honor, on December 2nd, 2025, at approximately 6:10 in the morning, I was dispatched to a PDA in the area of northbound Greenfield and 13 Mile. As I came on scene and talked with Unit 1 and Unit 2, it was explained to me that Unit 2 was stopped on northbound Greenfield at the red light at the 13 Mile intersection in the far right lane. Unit 1 was driving northbound on Greenfield approaching 13 Mile. Unit 1 failed to stop in an assured clear distance, causing him to rear end Unit 2. The damage on both of the vehicles was consistent with this story, and Unit 1's driver, being Mr. Prince, explained that he felt he didn't have enough time to stop because of the ice.
Okay. Mr. Prince, it's your turn, sir.
That is correct. I didn't have enough. I stopped within enough time, but the black ice on the ground caused me to slide into the car. According to the Life 360 that I use every day, it says I was going 11 miles per hour at the time of the crash. So I wasn't speeding. I was paying attention to the road. It was just a matter of bad road conditions at the time.
It's your responsibility as the driver to accommodate your driving to the road conditions that exist. It's your job not to hit stationary objects.
That's correct. That's correct, Your Honor.
I don't know who's telling you what to say in the background, but that's quite inappropriate. If you can drive a car in the streets of the state of Michigan, you can appear in court and indicate what happened. The fact of the matter is the vehicle you hit was stationary, was it not?
Yes.
So you hit a car that had stopped. How is it that the car in front of you was able to stop and you couldn't?
It could be likely due to driving experience, as I am a new driver.
Say that again, please.
It could be due to driving experience, as I am a new driver, and this is my first Michigan winter while driving. Is there any way I can not have points on my record, because I want to get I'm currently applying for internships, and I know that a few of the internships I'm looking at require clean driving records. So
Mr. Prince, you denied responsibility. You've taken an oath, you've testified as has the officer. Once the hearing is commenced, I have two choices. I can find you responsible, or I can find you not responsible. By denying responsibility for what happened, you have eliminated the option of addressing this matter in different ways. We've only got two choices, responsible or not responsible. And it's clear that you drove into a stationary object. Stationary object was a vehicle that managed to stop on the same surface that you couldn't stop. So you're clearly responsible. What happens when you're behind the wheel is your responsibility. The fine and cost needs to be paid. The points are a function of the Secretary of State, not the court. The court does not give points. But the fine on this is $195. The Secretary of State is going to give you an opportunity to take an online traffic safety class to stop the points from going onto your record. If there was a traffic report, a crash report done in this matter, or if there was an insurance claim, your insurance company already knows about the crash and you've already got the insurance points. But the fine is $195. You can pay it online or by mail or at the courthouse counter. Thank you.
Thank you, Your Honor.
Good day.
Glad that you show up as frequently as you do. I didn't realize you were here because I had told you you didn't have to, but I appreciate your diligence. I have to adjourn this to next Monday. There is a plea offer on the table. Counsel's requesting a 1-week adjournment to discuss it with his client. And next week on Monday, when we come back, if the plea agreement is not taken, we'll set a jury trial date. So I'm not going to set any more future dates. He's taking the plea or he's going to trial. Okay.
Okay. So next Monday at 9 a.m.
Correct. And your client must appear in person. Okay. I said parties are working on a plea agreement on next date. If plea not taken, set jury trial date, no further adjournments. Defendant must appear in person. Anything else?
That's gonna do it, Your Honor. I appreciate
All right.
your diligence. Thank you.
Thank you. All right, we're all set. Ms. Sawadna, you'll get notice, but it's January 12th at 9 a.m.
Okay, thank you.
All right.
Thank you, Your Honor.
All right, we're all set. Thank you.
This is what they'll do.
I don't know. I wrote a note. Or anyone else on Zoom? Does anyone have anything ready?
I'm ready on Mr. France. I've got the file here. Let me send it in.
Franz. All right, I see him. Court officers meeting you for the file or coming to get the file. Mr. Hamoud, I see you have Abdeen.
Yes,
Is
Your
your
Honor.
client with you?
No, Your Honor, I'm going to waive his presence.
Oh, it's a ticket. Okay, give me 1 second because I've sent my court officers out to get files.
No problem, dear.
Miss Maddox, what do you have today?
Good morning, Your Honor. Renters on Foley.
Foley?
Yes.
All right, I see that. Oh, I see that settle or set for 9 AM. I'll see if she's checked in anywhere. Monica's here. Monica Foley's here. Okay, she is here, so we'll get, does the defense counsel, one of them have the file on her?
Yes, I believe.
Okay, great. All right. So one of the attorneys does have her file.
Yeah.
All right.
Your Honor, I can come into the courtroom.
Fanto has.
Oh, you're here in person?
I am.
Okay, give me one sec here. All right, first, this is the People versus Sufanzine Abdeen 25X4623280. Counsel, can I get your appearance?
Yes, good morning, Judge. Excuse me. My name is Ali Hamoud. My P number is 73076. I represent Mr. Abedin. Waive his presence for this pretrial hearing.
Okay, and I see there's a plea form in here from the prosecutor that it would be, I don't know what double impeding means.
It was, I think
Double
she,
parking and impeding?
no, one or the other. I think she didn't know if there was a double parking or an impeding with the city.
It's impeding for state.
That's what I told her.
All right, so, and you have authority to enter into that on behalf of your client?
I do, Your Honor.
The allegation that your client impeded traffic in the city of Taylor on November 15th at 25, how do you plead, responsible or not responsible?
Responsible.
All right, I'll accept the plea as knowing and voluntarily given. That's a fine of $165. Your client has 7 days.
Thank you, Judge.
All right, have a happy new year.
Thank you, Timmy.
Thank you. All right, and then I have Mr. Franz in the courtroom.
He's on Zoom.
All right, there we go. This is 2533653 SM, the People versus Dylan Franz.
Good morning, Todd Barron, appearing on behalf of Mr. France. I spoke with APA on this, and we're asking the matter be set for a settlement conference. I reviewed Mr. France's bond conditions with him as well today and reminded him that those remain in effect and to abide by them.
Tell me your first and last name.
Dylan France.
All right, is the complaining witness here today?
She has not appeared.
Okay, so we'll set a settlement conference with complaining witness to appear. And sir, we'll send you that date out in the mail, okay? Your bond conditions continue.
Thank you.
And you're all set for the day.
Thank you.
All right, thanks. So Miss Maddox, hi, how are you?
I can leave.
He was actually told he could leave the state.
Oh, I see. He can travel to Indiana for purposes of work only.
Yes.
Okay.
He's working at the Ford plant down there. Here he is on.
Zoom.
All right. Okay. He had an exception. All right. This is the People versus David Zacharias 253806FY.
Good morning, Your Honor. James Mikowski, P62115, appearing on behalf of David Zacharias, who's also appearing via Zoom. We waive in-person hearing, consent to proceed remotely.
All right, 1 second. All right, I'm going to see if I can bring the other complainant is in with the prosecutor and the victim's advocate. But counsel, I'm not giving that long of an adjournment on an adjourned PCC. I can tell you that.
Well,
give me just a moment. Just give me a second. Let me get a minute. And Mrs. Morrow, I'm trying to get Mr. Cook out as well. I just called this case and realized they weren't out, so I can put you back in a room. Here we go.
Good morning.
All right, so now we have everyone present. We're on the record on David Zacharias. I see I have a complaining witness present. Mrs. Morrow, can I get your appearance?
Of course, Your Honor. Good morning. Nathaniel Asmer on behalf of the people, BA8493.
All right, so this is the time and date on this case set for the PCC. Defendant's previously been arraigned. And I see there's paperwork in here that indicates that defense counsel is requesting an adjournment for an adjourned PCC until January 29th to review discovery.
Well, Your Honor, I got the date wrong. I don't have my glasses on. The next month that I was actually asking for January 26th because that's a Monday.
No, I'm not going out free. If you want to set an exam on January 26th, I'll set the exam on 26th, or I can set a PCC on the 21st, but I'm not going out. That's 3-week adjournment for a PCC. I'm not doing that. I'll go 2.
That's okay. Yeah, fine, Judge, that's fine. I've got a private investigator working on this, and I got to give her time to work on it.
All right, well, he was arraigned on December 26th. I'm letting you take the PCC out 2 additional weeks. So we'll come back for an adjourned PCC on January 21st at 9 a.m.
Will that be on Zoom as well, Your Honor?
You can, yes, via Zoom. And then I want to set the exam date as well. So we can set the exam date on February 2nd.
Your Honor, I've got to be in St. Clair Circuit. You know what? I think that's the afternoon docket, so I should be fine.
What, you want to set it in the morning?
It would have to be in the morning because I have to be in St. Clair Circuit in the afternoon on February 2nd.
All right, I can set an exam on February 2nd. Right now, I don't have much. Can we do it at 9:30 a.m.?
Absolutely.
All right, the preliminary exam, and this is for Mr. Cook, Ms. Swinia. The preliminary exam will be set for February 2nd, 2026, and that'll be at, did I say 10 a.m.?
9:30, you said.
And that is in person. So all witnesses, the complainant and defendant and attorneys almost appear in person on February 2nd. But on January 21st at 9 a.m., everyone can appear on Zoom. Understood?
Thank you, Your Honor.
All right, we're all set. Bond will continue, and we'll see everyone back on January 21st at 9 a.m.
Your Honor, I guess I should say for the record, I did advise my client he has the right to have a preliminary examination within 21 days, and he voluntarily agreed to waive that right.
Is that correct? Mr. Zacharias?
Yes, Your Honor.
All right, I'll accept the waiver. We're all set. We'll see everyone back next week or in 2 weeks.
Thank you.
Thank you.
Bye. Thank you.
Thank you, Your Honor.
Thank you. Thank you. And everyone, do you want me to put you back? Do you want a room with Mr. Cook again?
Yes, Your Honor.
All right, and thank you, Ms. Dennis. I'll get you 2 back in a room.
Thank you.
And Mr. Cook, you're going to see something inviting you to join a breakout room. Make sure you join that room, okay?
Understood.
And, uh-oh. And Ms. Swinia, you're all set for the day, and we'll see you at the next court date, okay?
Thank you.
All right, you're all set. You're welcome. Bye. All right. Mr. Zacharias, you can look up Monica Foley. Can I get the Monica Foley file? Miss Foley. Miss Foley, did you already meet with the attorney?
Yes. Yes,
All
I
right,
did.
give me just a minute then. I'm waiting for the file.
I'll go, Your Honor.
All right, thank you. Right, this is 2-5. This is the state of Michigan versus Monica Foley. This is 2-5-3080-SM. Can I get appearances?
Good morning, Brittany Maddox on behalf of the people, P83204.
Morning, Your Honor. Jeffrey Fanto on behalf of Ms. Foley. May I approach?
You may.
Assessed matter to be set for a bench trial.
Okay.
No, I'm just double checking before I go tell them.
All right. I want to set a time and date now, but I don't know what, I don't have Miss Maudlin here to look up my calendar and give me the dates that we have available. So I'm going to ask the clerk downstairs to find the date and set it forthwith. And then I will have her email both of you so we know when. I mean, Mr. Fanto's here either way, but I need to set it as soon as possible. She's in custody.
Just as long as would be set on Monday?
I can't set it on Monday.
Okay, okay. I just can't do it next week.
Okay, all right, but I'm guessing it's gonna be at least 2 to 3 weeks out. But I can't do it on a Monday in the middle of this docket.
Okay.
So I'll get Dana to give us a date. How many hours do you think the two of you will need?
Yeah, Your Honor, I would say no more than 2.
All right, I'm gonna ask her to block off some time. Ms. Foley.
Yes.
I have to ask you some questions, ma'am. You understand you have a constitutional right to a trial by jury?
Yes, but we decided to go with the bench instead.
Oh, okay. I just have to ask you this so I can make my record, okay?
Okay.
And are you waiving your right to a trial by jury and electing to be tried by the judge of the court?
Yes.
And do you fully understand the laws of the state, and that you have a constitutional right to the jury trial?
Yes.
All right, I'll accept the waivers, knowing and voluntarily given. We'll get the two of you a date. I will try and get this on the calendar in the next 3 weeks.
Thank you.
All right.
Thank you.
All right, we're all set. You can let them know you're all set at the jail.
Thank you so much.
There you go.
Thank you.
All three. He did join, Master. He did join, yeah.
Hi, sir at the jail, can you tell me your name?
That's fine, Your Honor. I believe, no, it's not. That was Mr. Blanchard. Is that Mr.
Oh, he's gone. I don't know where he is. All right, I'm Milton Garcia. Let me see if we have a complainant present.
I don't believe she appeared.
She did write a letter. Did you have a chance to look at that with your client?
No, we haven't, Your Honor. Is it something that we're not going to object to the recommendations, so if it's unnecessary, we don't need to further add.
Multiple pages long.
No, that's quite true.
All right, I'm gonna just put some, let me call this. This is 2524 SM, the People versus Milton Garcia.
Edward Zelenak, on behalf of the defendant, Mr. Garcia, please give your name clearly and loudly to the court.
Milton Garcia.
Well, on her letter, which is very concerning to the court, she has pictures of bruises, broken windows, hair pulled out, bald spots on her head. Bruises on her wrist, a busted lip, a head cut on her head. Those are, I mean, what she wrote is incredibly heartbreaking. She basically says she's since the beginning of the year, this is 2025, the mental and physical abuse from the defendant has been ongoing. I've lived with a cycle of fear, anxiety, and emotional distress. She has photos and videos attached. I can't see the videos, obviously, this was just printed out. What devastates me the most is that my 3-year-old son witnessed many of these episodes. Is that your son too?
Yes.
He is so little, yet he has already been exposed to things no child should ever have to see. I cannot forget the moments where he stood there confused and terrified, watching someone he should have felt safe around yelling, breaking things, or hurting me. It breaks my heart to think these memories may stay with him. No child deserves to grow up in that kind of fear and chaos. Goes on to say you have serious anger management issues. Her greatest fear has always been and continues to be that you will lose your temper in front of her son or your son, especially if she's not present there. The most recent incident was the most terrifying. While I was sitting on the ground, the defendant stood over me and slapped me in the face, not once, not twice, but 3 separate times. My 3-year-old son witnessed the entire assault and cried, begging him to stop and get away from me. Several neighbors also witnessed the assault, and it was only when one of them intervened and told him to leave that he finally walked away from the scene. All right, Mr. Zelnick, as the pre-sentence investigative report, have you had a chance to review it?
It's accurate, and we'd ask for adoption. And Your Honor, it's only parenthetically that I could say I can't respond to written correspondence. At the previous hearing here, I made an attempt to introduce to the court some of the toxicity of the relationship between the parties. There's always
Don't victim blame though. Like could try and, I mean.
I'm not going to do that, Your
Okay.
Honor. That's what I'm saying is I'm not going to try to rebut or question what she wrote. That's her statement that she
reality.
made. And whatever's happened, Mr. Garcia came in and pled guilty, and we accepted the pre-sentence recommendations. They're not together now. And The reason I bring that up, Your Honor, is I was contacted when Mr. Garcia was taken into custody. And at that point, the officers indicated that there was a variance in the story and they didn't think the victim was going to proceed. So Mr. Garcia's come in and he's done the right thing. He's pled guilty. We'd ask the court to adopt the recommendations, but there's no reason, as I said, that's why I wouldn't read a statement, because all it does is fuel drama, Your Honor. Whatever's happened in the past should not be prologue. Mr. Garcia should go on his separate way, and that's what he's done, Your Honor. He's living with his mother in Lincoln Park. He's the manager of a construction company, and he works 40 to 60 hours a week.
I mean, there was a third party witness to this. It wasn't just her word. There was a third party that got involved.
Mr. Garcia pled guilty.
I know, but
And-
I'm just saying, he pled guilty, I get that. But it's concerning to me when I see he's got a prior DV case. He's got a
long time.
prior, well, and you know what, Mr. Zelnick, you know how much I respect you, and I know you're advocating for your client, and I know that's your job. But this guy's got a problem. You've got a problem, and I'll tell you why. You didn't learn anything in 13 years. You didn't learn anything in 12 years. You're still beating women. What's wrong with you? Something's wrong with you.
Okay.
That you behave like this. And I remember your case because this woman told you she didn't want anything to do with you anymore. And you were sending her flowers, trying to pay her bills and doing this and doing that. And those are just other forms of abuse, right? When a woman tells you no, what's it mean?
No.
That's right. And that's something you're going to have to learn. Because if not, you're going to end up, you're just going to keep escalating. You'll be back. If you don't figure something out and figure out a way to, and I don't know if you saw that when you were growing up and that's how you think men act, but it's not how men act. It's not how men should act. So you get to decide the kind of human being you want to be. Because right now it ain't looking good. Slapping a woman in her face in broad daylight where neighbors have to come out and intervene. And I mean, your ability to do that right, most types of abuse, like domestic abuse, they happen indoors, right? Sexual assault, things like that. They don't happen in the public. They're secret crimes, right? And the fact that you had the audacity to do this in the open, in a neighborhood in front of your house tells me what you do behind closed doors is even worse. And it gives credibility to her victim's impact statement that you were comfortable behaving like this in public. You have a fine of $50, court costs of $50, state costs of $50, plus a victim's rights fee of $75. You have probation oversight fees of $450. A community service fee of $10 a day for a total of $50. It says restitution to be determined at a later date. I don't know that there would be any. It doesn't seem like she received medical treatment for this, so I don't know. He's got probation, 12 months. He's got 5 days of community service, 40 hours in the city of Taylor, is directed by probation and provide proof. He's to abstain from the use or possession of alcohol or controlled substances unless prescribed by a physician. Documentation will be required, and that's for the term of probation with random drug and alcohol testing is deemed necessary. You're subject to drug and alcohol testing at your expense. You must complete the batterer's intervention classes as directed by probation through ETRS, provide proof and follow all therapeutic recommendations. You're to attend and complete any other ancillary services deemed warranted. You're to have no contact with Dayanira Esquivel except for child custody issues through email, which is what I ordered in my bond conditions. You're to maintain employment and provide proof. You're to have no weapons, ammunition, or firearms. You cannot operate without a vehicle without a valid license. If you weren't fingerprinted, you're to be, and you're doing 5 days in jail. Forthwith.
Your Honor, you give him 2 days credit for the time he served in the time of arrest. How many days is it, 2 or?
Two.
And will they permit him to make a call to his employer on it? Because
He can make a call, but I'll give him 7 days credit too. 5 days in jail for what he did is, I'm being nice.
Yes, okay.
He can make a call though. I'll let my court officers know.
you want to say anything else?
Yeah, I need a call because my dad's sick and I really want to take care of him.
Well, you should have thought about that before you started hitting women.
Okay.
All right, you make a phone call.
Right. Very good. Thank you. Thank you, Your Honor.
All right, thank you.
Judge, I wanted to indicate that I'm not quarreling when you read a statement. It's just,
Mr. Zolnick. All right, this is 253428SM, the People versus Kyle Green.
The complaint is a great government judge.
All right, let me get her. Mr. Blanchard, did you already meet with your attorney?
Yes.
Okay.
Just a process explaining that to plan.
All right, this is 253428SM, the People versus Kyle Green.
Morning, Your Honor. Jeffrey Camp on behalf of Green. William Green is present on Zoom as well. Set this matter for jury trial, Judge.
All right, let's get a date. We're into like I set someone for next week out. Or 17 or 4/24. Those are the first dates I have, and I think I'm setting over, I think I might already have trials that day.
Well, there's something set for that day.
Both days.
I think so.
Yeah, so that takes us to May 1st, which is Law Day. So we won't have one that. So the next day is May 8th.
That's fine. My 26
5/8/2026. So the jury trial date on Kyle Green will be May 8th of 2026. I apologize for the delay. I'm the only judge here, and that's my first date. Is this Miss Louie or?
No, this
So-
is from Ms. Soap's case.
Okay.
And I'll let her sub today know.
All right, thank you. All right, that's the jury trial date. Bond will continue. I'll also set a final settlement conference. It'll be a week or two before that date, so you'll receive a notice in the mail. It's going to have 2 dates on it. The first one, the final settlement conference, you can appear via Zoom. The second date, you must appear in person, which will be your jury trial date of May 8th of 2026.
Thank you.
And we're all set. Bond continues.
All right, thank you. You're all set, Mr. Green.
Okay, thank you.
Crazy. Antonio Hernandez, are we ready on that?
Sure, Honor, we're ready.
All right, this is 2523500 SD, the people versus Antonio Hernandez.
Good morning, Your Honor. James Gazicki on behalf of Mr. Hernandez. We waive reading of the complaint and stand mute. And if I could address the court prior to bond being issued. He's going to plead to count on operating while intoxicated, first offense. The high blood alcohol content will be dismissed. It's going to be a no contest plea. We'll stipulate to the blood draw being a 0.19.
Okay, thank you, Mr. Gazicki. And is there, so I've entered a not guilty plea for purposes of arraignment. Is there something you wanted to tell me about before I impose bond conditions?
Yes, Your Honor. Mr. Hernandez lives in Texas. He works throughout the United States. I just wanted the court to be aware of it, that he's not a Michigan resident, and if there would be no restriction on him traveling the state to state with work, Your Honor.
Okay, so we'll allow you to travel for work. You live in Texas, sir?
Yes, Your Honor.
All right, I'm going to allow you to appear at your hearings via Zoom. See. Do you have any prior drug or alcohol related offenses?
There was not a thing from Texas on him, but I believe he does have a prior, Your Honor, according to police report.
Sir, you have a prior OWI offense?
Yes, Your Honor. I think so.
What year was that?
23, I think.
So recently, okay. All right, sir, I mean, you've appeared today. I'm giving you a $2,500 personal bond. That means you don't have to post any money. I'm allowing you to travel for work, and I'm allowing you to appear for court proceedings via Zoom. You're to appear in court as directed. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Was there an accident?
Yes, there was, Your Honor. That's purpose of the no contest plea. The restitution to be determined.
Okay. And the complainant did not appear today?
To my knowledge, I'd say no.
All right, I just want to, let me just check the breakout rooms.
Okay.
Seeing none. Okay. Sir, you're not to have any contact complaining witness on this case, Kylie Reisig. I'm guessing you don't know her.
No.
Okay. You can't contact her. You can't comment about her on social media. You can't go to where she lives, works, or goes to school. You're not even in the state. So I don't think that'll be an issue. You cannot possess, consume alcohol and illegal drugs. You will be subject to random drug and alcohol testing, given that this is your second offense within the last few years, and you're alleged to have had a blood alcohol level of over twice the legal limit. And the probation department will contact you, Mr. Hernandez, to set up that testing at a facility located near you. Understood?
Yes, Your Honor.
And you cannot operate a vehicle without a valid license. So those are your bond conditions. You are going to be on testing. Now, there's a plea offer that's been made where you would plead to an operating while intoxicated first offense. Operating while intoxicated first offense is a misdemeanor. It's punishable by up to 93 days in jail, a fine of up to $500, 6 points on your license. We have the complaining witness here. Is that one? No, that's for a different case, yeah. Do you understand all of that, sir?
Yes, Your Honor.
And there may be issues with licensing. I can't tell you about that. That'll be up to the Texas DMV or Secretary of State, whatever you call it down there. You understand all of that?
Yes, Your Honor.
Okay, and you could get up to 360 hours of community service as well. Sir, did you go over your constitutional rights that are outlined on this advice of rights form? Did you go over these rights with your attorney?
Yes, Your Honor.
All right, did you go over the right where you explained to you have a right to a trial by judge or jury? At that trial, you'd have the right to call witnesses to speak for you at trial, and you can get an order signed by the court requiring them to come to court?
Yes, Your Honor. With the attorney.
You did? Okay, well, I'm gonna just read them to you to make sure. You also have a right to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. And lastly, you have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. You understand all of that, Mr. Hernandez?
Yes, Your Honor.
And Mr. Hernandez, you understand that if you enter a plea, a no contest plea or otherwise, to the court, a no contest plea has the same effect as a guilty plea. Do you understand that?
Yes, Your Honor.
And the reason for the no contest plea is civil liability?
Correct, Your Honor. Yes, Your Honor.
Thank you. And sir, you understand that if you were currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions?
Yes, Your Honor.
Okay. And you understand that if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation?
Yes, Your Honor.
Knowing all of that, sir, how do you plead to the charge of operating while intoxicated first offense?
No content.
Has anyone forced you to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea agreement to get you to enter the plea?
No, Your Honor.
Are you pleading guilty or no contest of your own free will?
My own free will.
Your own free will. Okay, Mr. Kazicki, I see there's a stipulation of the BAC level of 0.19. Can I review the police report to establish a factual basis?
Yes, Your Honor.
Okay. All right, I find that the police report does establish a factual basis, and I'll accept the no contest plea to operating while intoxicated. And so, Mr. Hernandez, you're going to hear from the probation department for 2 reasons. 1, they're going to help you set up your drug and alcohol testing. And 2, they're going to set up an interview with you where they meet with you prior to your sentencing, okay? And then they'll help me come up with an appropriate sentence. You'll receive notice for the sentencing date once that pre-sentence investigation's occurred. You understand?
Yes, Your Honor.
All right, you're all set for the day. Have a good day.
Thank you. You too.
All right, thank you. And Mr. William Green.
Yes, sir. Yeah, you need to be in here, sir. This is where all the activity is. What's going on outside? Nothing? Nothing. You need to be in here when we call your name. So that, because if you don't answer, your bond can be revoked and then you get taken into custody, which is not the way to handle things. Have you talked to your attorney?
I have not seen him today.
Okay. I don't think, well, I have a note that says he's on jury duty this week. I just got this note. And, I thought you were on jury duty.
I am, Judge, at 1 o'clock.
Okay. This one is trial? This is trial?
Yes, sir.
Okay. All right, if we have to try it, you're gonna talk to the judge about missing jury duty or anything? Well, I mean, this is Judge aggravated a sexual assault of a child. That's got to take precedence. And it's 1,000 days old. I'm not sure where we're going to be on this because I got some older ones.
I mean, I'm not trying to be wise guy, Judge, but
Elvin, we'll talk about it. Elvin Bryant. Okay. Let's rotate through this thing. Elvin Bryant Jr., Bruce Smith.
Then Mr. Smith is running a little bit late this morning, Judge.
Okay, Ernest Thomas.
Yes, Judge, he's here today. He's brought some new information to me. I think I have to try today if we can, but I'd like to get a little information from him.
We're ready, Your Honor, but I mean,
do I have anybody else we can send something to?
Huh? Let's do what?
Actually, look at the number on your round.
Don Xavier Sand. Anything new on this? Anything new? It's still a trial.
Happy New Year, Judge.
It's still a trial. Yeah,
still a trial.
Some things rain on the parade, but.
Judge, I have videos in this case that I can hear the audio and I can't see. I've requested them since December 17th from law enforcement. Still haven't gotten a new copy of it. I reached out to defense counsel and his videos work the same way as mine. So we need time to get those videos from law enforcement. I'm gonna have to go up the chain a little higher.
We'll be ready anytime to get some.
Well, okay. Abner Castro. Tom Burbank.
We haven't called it. I do 14 visits.
I'm sorry.
Okay.
Abner Castro there is no answer here in the courtroom. I ask the bailiff to call into the hall for Abner Castro.
He's coming, Judge.
We're here, Judge. We're ready.
And Travis Jackson.
There you are.
And Sincere Stevenson. Todd LeBlanc.
Haven't seen Mr. LeBlanc this morning.
Mage McMillian.
Ready, Your Honor.
And Terrell Hope.
Yes, that's mine.
Still trial.
Yes.
And John West on Patricia Eaglin.
Thank you, Your Honor. I'm ready if we get to it.
And Terry Weirin,
I can, be ready to get to it, Judge.
with Demond Sargent,
Yeah.
Mr. Delage.
She's next door. She said she'd be here just to shortly, Judge.
Charles McDaniel, Ryan. Charles McDaniel, sexual assault child.
She just, oh.
Ready. Burglary of the building with Turk, Mr. Turk.
That's a plea, Judge.
And Patricia, Patrick Winston. That's also
Or our.
Patrick Winston. Patrick Winston, no answer in the courtroom. I asked the bailiff to call into the hall for Patrick Winston. You okay there? Are you Patrick Winston?
Yes, sir.
You need to be in the courtroom. I can't go out and get you. You need to come in here. You're charged with aggravated sexual assault. And have you seen your lawyer at all today?
I haven't seen my lawyer.
Okay,
since I got
but you all ready for trial? Let me see Robbie Kelly Jr. Robbie Kelly. Well,
Mr. Turk is in the back. That's a plea, Judge. We're just waiting on the tablet to work so we can sign it.
okay. Thomas 1, Marshall 2. Mr. Gertz, where's Ron? When do we roll this over? Just one day, 1 week?
Well, no, Judge, I've got,
It's 1,000 days. Oh my God.
actually, I've got Nemola in 1 week, so. And if even if Nemola would not go by some crazy.
Okay.
Then I've got
3, 4 weeks.
4 weeks.
I know y'all love it. All these sexual assaults, children. Just there's no end to this. Elvin Bryant, where's Mr. Bryant again? That's you? You're 3. And there's Thomas.
You know, I see.
4. Just was resent. And Abner Castro is 5. I think that's about all that really makes the reset.
Thank you.
Yeah. All right. That's not a problem. Yeah, that does help.
They call this, but.
I'm gonna check. See you.
I like this. Charles been with us, reads, but.
Uh, 17 cases, nothing.
We got, will probably be pleased as Mr. Smith gets here, Judge. Get out.
I mean, yeah, I know, but still, the 17 doesn't, all it does is put more in the queue. Try one at a time. All right, come on. Let me know when Kelly is done. Ready? Okay, on these other ones, Dan Shelton.
Hey, Judge. Mr. Shelton.
I need today's, please.
You want the whole stack?
Jared, maybe.
Yeah.
Yeah.
And I think you had 2 files on your desk.
I didn't.
Okay, I'm gonna go full.
Thank you. On Dan Shelton?
Hey, Judge, on Mr. Shelton, I had him first in misdemeanor court, filed a motion to have him tested. He came back insane, so they're looking right now, need to place him at the if I'm not mistaken.
That's the notes I have as well, Your Honor.
But he's already been found incompetent.
He's been found incompetent on the misdemeanor case, not this case, but he's waiting on a bed placement on the misdemeanor.
Worried about the rest of the on this case. I can understand on the misdemeanor, but we got to make the record clear in this court on this case about his competency.
You want to see if I can, with Judge Holmes, I can go next door to Judge Holmes and see if they can find a copy of the order.
Yeah, that's what we need.
That's easy. I can do that.
Yes, sir. But just put that on the record. Was that him?
Yes.
Oh, okay. You're Dan Shelton. You're Dan Shelton. Yeah. Happy New Year. So just, so he's charged with third-degree felony of harassment of a public servant, and he also has 1, 2, 3, 4, 5 prior convictions. He's an habitual felon based upon this indictment. So he's looking at no less than 25 to life years in prison if found guilty. But there's a misdemeanor case that apparently the misdemeanor court took care of previously, and that's pending and on the defendant, and he was declared incompetent. And that it was what was based upon a report and analysis by Dr. Ed Lapon. You don't happen to have that with you. I don't have it in the file, but I do have notes about it.
I can go out next door and ask them and make a copy.
It needs to be placed in this file, but the court is going to make findings based upon the court's records and based upon the statements made by a defense counsel that the defendant, Dan James Shelton, has been declared incompetent to stand trial by an evaluation of Dr. Ed Lapon, licensed psychiatrist. That says the doctor regular reviews in the determinations on competency issues or cases in this court. We will get a copy of his report that was prepared and used in the findings in the misdemeanor court here in Jefferson County, Texas. And then the court will apply those findings for this case, and we will monitor that matter for his treatment and prognosis as changes develop with him, and more information is discovered according to the treatment that he would be receiving. Did the statement say anything?
No, Your Honor, I think that about covers it.
Okay. And there's this state's belief is in accordance with what Mr. Adams is stating, as well as you know.
Yes, Your Honor.
There's nothing to believe out there. You don't have any information that's not in Congress.
I believe there was 4 or 5 misdemeanor cases that he was found incompetent on. We don't have anything that provide that he is actually competent to stand trial.
Then that would be reset for review.
Thank you, Judge.
And outside.
Next is Jacoby Broussard.
That's
Where's Mr. Cole?
I used to have him.
You used to have Mr. Cole?
I used to have Broussard.
So he's on his way or something?
And that, so he called one.
The defendant is in custody?
Yes, I do.
Thanks. We'll hold that one. And that's two cases, I believe. Ken Dirk and Antoine. Reagan?
Morning, Judge.
Sit down there.
Judge, I've spoken to Mr. Brown about this case. I'm still waiting on, it's not with the media. I have not had a chance to do that with my client, but I do have an offer. I think it's just get 2 to 3 weeks to go through that then. I think that we could get something figured out.
Mr. Boyd?
Penalty in the case, which is 36 months in prison. But I'm envisioning that you will do your 90 days in jail and be successfully terminated from probation upon your release. You do have the right to appeal this to the 12th District Court of Appeals in Middleton. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you without charge. Good luck to you, Mr. Summers.
Thank you, Your Honor.
Yes, Your Honor. I believe she's just got the media on it, so she doesn't need to go through that.
Just 2 weeks good?
2 months.
We're set 2 weeks on this. Thank you. Michael Osborne.
Judge, I do not have media on that for a minute, but I was just 6 months.
Here's two. He find me letters. Then these filing motions.
What I would like to do, Judge, if he may, or if you'll let me, is to get my hands on the media so I can sit down and go through everything with him. And then if he's still, I've been put on alert that he might potentially want to be pro se in this matter, but I would like to go through everything with him and make sure that he makes that decision. Informed. So if I could have 4 weeks just to accomplish that with him and figure out what he wants to do. He is enhanceable to a second degree. That's correct, Your Honor.
I think he understands that.
Yes.
What's the offer on this?
We've spoken about a few options of not enhancing just yet and leading to the state jail. But we just shared discovery this morning. And so I know Ms. McNally needs time to go over that before signing up. And I need to make sure he fully understands what it would mean to be pro se, especially given the potential enhancements.
And I can't.
You came up to that part, we're getting on part.
Yeah, I don't know what's.
Oh, first few minutes, there it goes.
Okay. We've got it. Second, said 4 weeks of request. Brian Rodriguez. That's 3 cases.
Yes, and he has 2 more that are coming down that might inform me of this morning. So I believe we're both requesting time to make sure that we can handle all of it together. And since the first one is a motion to revoke probation, the new offenses are not alleged in that current motion that you have. So a new one needs to be tried. I think Mr. Mayor is wanting to find this updated. I have the first amended administrative during the future.
Say that again.
This is the first amended and in here.
And we see what happened in those cases. You know, no, I'm embarrassed.
Okay, this is something, an administrative hearing dated December 29th. Last week. And well, they're working fine up here. And the court has reviewed this. I'm going to sign it, approving it this date. You got a copy of this?
No.
Which recommends the filing of first amended motion to the probation, which is our administration.
Bill report since.
Well, that just looks like two more
There's two burglary,
legal acts.
there's a burglary of a vehicle and two burglary of a building.
All this trouble. Oh, I'm very confused.
Hard to get used to 26.
26. For some reason, I've had an easier time with that.
Seems like a year. I'm choosing 25. Okay, it's been signed. Do I give it to?
I think it would be good.
Yeah. And then this motion to revoke probation was reset for review in 2 weeks.
3, Judge.
3. And
That's all, Judge.
all right, we're going to do this motion to revoke first, I guess. We got these other cases. I'll just handle this first.
Okay.
Okay.
Thank you, Judge.
That on our friend? Yes. Okay, there we go. 3 cases, 2 new indictments and a motion to revoke. Kristen Smith. No. Two cases that are pending, correct? Come on out. Two cases, which are clause numbers 23C1745 and 1746. And you are Mr. Nutt here with Mr. Robo and Mr. Radford, your attorneys. Earlier, the defendant entered this. You've entered pleas of guilty already in these cases, correct?
Yes.
In each case.
Yes, sir.
And clause number 23CR1745, the defendant was indicted on October 18th of 2023 for the second degree felony of manslaughter by vehicle. And in 23CR1746, he was indicted for the second degree felony accident causing death. Each of these, the victim is the same individual, Christian Michael Sykes, correct?
That's correct, Your Honor.
Pre-sentence report has been prepared in these cases. Have the parties had an opportunity to review them?
Yes, sir.
Yes, Your Honor.
This information, is there any changes or corrections that need to be made
No, Your Honor.
Now, let me get this straight because it's not in the jacket here. The defendant entered a plea on 1745. He didn't enter a plea on 1746.
He entered on both, Judge.
Okay, where's probation office?
We don't have,
Okay,
this was done by Margaret Carson, who's usually our liaison, but she did the pre-sentence report.
okay,
But there's,
okay.
this is a split sentence, Judge. If you, and on one case, which is cause number 1746, I think 14406. Yeah, we are doing a 3-year prison term. And then on the other case, we're doing a 10 years deferred probation with certain conditions.
And these sentences are to run concurrently.
Yes, sir.
Right, everybody?
Yes, sir.
Okay, so once again, the pre-sentence report is presented to the court. I've reviewed it and there are no objections by either party.
That's correct, Judge.
No. And it's made a part of the record for all purposes. All right. Just a summary from each side on this. I think I know where this is headed for what you want, but I just want statements, summary from either party as to how this plan is in the best interest of justice for all concerned. Go ahead.
Judge, this is one that we've both struggled over and talked to each other multiple times on this case to try to find and fashion out a sentence that would reflect the seriousness of this, but also allow this young man to have a chance at his life. I've spoken with the family. We've had meetings on it and talked to them about this offer. Let them think about it over the weekend before we actually formally made the offer. They came back and said that this was acceptable to the family, the victim. This is kind of a strange circumstance because everybody in this community kind of knows everybody in this community, and they know this young man and know his family. And so
this community of
Hampshire. I'm sorry, Judge. It's just going through my brain for a minute. But this is something that we fashioned after looking at the circumstances and looking at this young man's past history and talking to the family. And again, what they're agreeable with this, and it's not the best of all the worlds that they would like to have, but it is something that they think would reflect the seriousness of this. And at the end of this, they also just to let the court know they want to make an allocution at the end of the sentence.
Go ahead, defense.
We concur with what Mr. Laird said. I would add additionally that this conduct, best I can determine, is completely out of character. No prior history of anything. What we did also, Judge, in light of the law change after this incident happened, there's going to be child support also and waiving it goes back to application.
Tell me a little bit about the deceased Christian Sykes, date of birth 77. So,
yes, sir.
So he was in his 40s.
Yes, sir.
Who else was in the vehicle other than Mr. Sykes in that vehicle?
His son was in that vehicle.
Was how old?
I think 4. I think he was 4 years old.
Injuries for that child?
No, Your Honor, minor stuff that didn't require any major treatment. Otherwise, it would have been more charges filed.
Anything you would like to add, Mr. Dunn? This court is inclined to follow this agreement. Anything you want to say?
Yes,
like you regret what happened here? And it seems to be inferred in here, but your version is one sentence long. It's just not a lot of.
Judge, I don't I don't know, he just said he wanted to say something to the family, but he's not going to get to it on the allocution because he won't be allowed to speak. So I don't know if his lawyers want him to say now.
Right now. Right, to me. The family, sometimes victims, relatives, the survivors are put in a bad spot here. Much less, and so are you, everybody involved here. And it's just, this is happening too often. This court's been doing this long enough. And in the last couple of years, this is the third situation I can recall now in just 2 years where people were left to die when people who were involved in an accident flee. And there's just a missing element of just human compassion. The law is a humanitarian type of law. You are required when you're involved in an accident to help, not leave, help folks who may be injured in the event. Here, you didn't. You're not the first, but I know what juries do, and they're pretty severe in holding defendants responsible in a situation like this. According to your version here, that's in the pre-sentence report, you had consumed too much alcohol, and as a result, you got scared and left the scene of the accident, and then one person died, and another, there was a child, could have died. And those are difficult situations for everybody involved, but this court always has a hard time figuring out why you just humanitarian compassion element that nature put us in. You have to compete with fear and not wanting to be around and to leave, which doesn't change anything except increases a burden that everyone is going to have to deal with. And then the question becomes, could a life have been saved by administering first aid until safety authorities, emergency authorities were able to reach the scene? And a death of a human is not reversible. And anything you want to add?
Think about it every day, a stupid mistake. Sorry to the family. I wish I could undo this and make it right somehow. I can't, and I want to help however I can, carrying on, however that looks like. I'll be right.
But they want their life back. That family wants that life back. You can't do that. Okay. That's the downside on all of this. And that's why, especially during this season where most accidents occur during holiday season, everybody needs to be reminded that this can happen at any time, and that they're responsible. When we are on the road, we are responsible not only for ourselves, our actions, but everybody else. We have a pact, an agreement that we will be responsible in our maintenance of a vehicle and operation of it in a sober and lawful manner. Vehicle is nothing more than a 4,000-pound missile. It does terrible tissue damage to humans when struck and takes lives. So there needs to be always a reminder of of life that, or the taking of a life in motor vehicles when we're driving is just a clock tick away from that. So we have to operate responsibly. All right. Anything else? I'm going to follow these agreements and find. Mr. Dunham, you have pleaded guilty in each of these cases. And again, in 23 CR 1745, the second degree felony of manslaughter, which carries with it up to 20 years in prison. And in 23 CR 1746, the second degree felony as well of accident involving death. Essentially, the two parts of these charges. One is by causing the death in a reckless manner of an individual by operating your vehicle on a public road in excess of 100 miles an hour and striking the vehicle, which caused it to flip and causing the driver to be ejected and died. And in the second case, accident involving death, when there is an accident, parties involved in accidents have a responsibility under Texas law to not leave the scene of an accident before giving name, address, registration, and rendering reasonable assistance to other parties when it's apparent they are in need of medical treatment. So those are the parts here: reckless misuse of your vehicle and driving irresponsibly, and then fleeing the scene after you had a duty to stay and render aid. In each of these cases, you have pleaded guilty voluntarily. These are second degree felonies, which carry with it up to 20 years in prison. You were mentally competent to enter these pleas of guilty. There is sufficient evidence supporting your guilty plea in each case from State's Exhibit 1 that was admitted at the plea hearing to find you guilty beyond a reasonable doubt. In 23 CR 1745, the manslaughter, even though there is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, the court is deferring any finding of guilt in this case, correct? And placing you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. The probation officer will go over these with you. You will sign these and be responsible for following the requirements, which also include participation in a 12-step program or tantamount program directed for dealing with intoxication, driving while intoxicating, operating motor vehicles irresponsibly, and there will be an analysis by the probation office as to exactly what type of program that will be required under these circumstances that the court will review and approve. You will complete a moral reclamation therapy program, which is a program that many probationers are required to complete. And essentially, it is a program which helps people make the correct decisions during the times of stress. And yes, we can all use something like that, but you are required to complete that as a condition. There will be other conditions of probation.
Just part of the agreement was that Jefferson County Drug Intervention Program when he gets out.
Well, I hadn't gotten to that one.
That's right.
You're going to, on this other case, you're going to be sentenced to imprisonment for a term. When that is completed, then there is what we call JCDI, the Jefferson County Drug Intervention Program, which you must complete. If you fail to complete any of these terms and conditions of probation in this deferred probation order, your probation could be revoked. You could then be found guilty and sentenced to no less than 2, no more than 20 years confinement in prison. Do you understand?
And since this is outside the child support statute that they have enacted now, we're going to ask that it be placed in the probation order that he paid child support based upon the child support calculations as directed by the family code.
Anything from the defense on that?
That's exactly right, John.
And
okay, is this going to be under Part 27 restitution, or is restitution under 27 to the victim family to compensate for property damage, monetary loss, or medical expenses sustained as a direct result? Is that separate?
That's separate.
That's separate.
Yes, sir.
Where is the?
I don't know if there is one on there, Judge.
I'll examine it.
If there's a blank, we can add a blank to it at the bottom and just write in percent to the family code.
What is it the state is asking for in the wording?
That the defendant, upon completion of prison sentence, pay child support
in an amount
direct as established by the Texas Family Code.
Pursuant to child support guidelines.
But there's a guideline set in the family code, and it's we just can't determine because he's going to lose his job when he goes to prison. When he comes out, we've got to figure out what that is. And it's going to be, I think it's 20% after certain expenses that's listed in the family code for one child. And that's what he'll be paying of his net. So we can't put what that is yet. Is what it is.
In an amount determined by what?
The child support guidelines of the Texas Family Code.
Right. Condition 31 of this probation order. Defendant shall pay child support to the victim's family in an amount to be determined by the child support guidelines of the Texas Family Code. What else do you want me to add on this provision?
All that is fine. I think leaving it generic probably is the best way to do it. It's all defined and good.
You understand the requirements that you're going to have, sir, as far as this set of orders in this case involving your deferred or unadjudicated probation for 10 years for this manslaughter charge?
Yes, sir.
the probation officer will review these with you and you can sign them and you counter them. Understand. Nice. Right now. Media don't say. Paper clip, try to write some paper stuff.
I can correct that for you, Judge. Get that, see?
Now you here, let me go look in the back.
I can correct it. I can correct it.
Okay.
Yeah. I'll make that correction for you, Judge.
Paper, it's small, but paper clip always. Now, anything else on 1745? If nothing, on 23 CR 1746. In that case, Mr. Dunham, you had pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 committed. In that case, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. In that second degree of the offense called accident involving death, I am following this agreement. You will hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And this sentence will run concurrently with the previous deferred or unadjudicated probation sentence in the 1745 matter. Do you understand what has happened here today, sir?
Yes, sir.
Anything else to add for the record for these cases?
No, Your Honor.
No, Your Honor. All right, there's something else?
There's some allocutions, Jeff. If I can, some more folks want to speak.
It's again, reading the pudding. We're fine here.
Dr. Mahal, podium. Welcome. Yeah. You'll tell me the other. This right over the podium.
All right, and would you please identify yourselves? I see there are 3 of you.
Yes. My name's Terrence Sykes. Christian's sister.
You were the deceased sister, Miss Sykes, and
I'm speaking on
the 2 ladies behind you.
I'm Amy Slano, I'm Christian's wife.
The spouse of the deceased.
Hannah Tolino, his stepdaughter.
And the daughter. Oh, go ahead.
I have spent months trying to write out what I would want to say. I've been completely unable to put it all into words. I thought and I could write volumes of stories and memories and tell you all of the amazing things about Christian and who he was. He was an amazing son, brother, uncle, father, husband. and tell you one of the things that I've been told about, and it's just telling you the week we had planned. It was actually an incredibly special week in our family. My daughter Grace was moving into her dorm at AM on the Friday after he was killed. That Thursday was my 44th birthday. And Christian and I and my mom and Grace all had plans to drive up to College Station the night before and then move Grace into her dorm room on Friday. Spend the day getting her ready. And instead, we spent the week planning a funeral. And because you still have to move into a dorm room, I drove up. Me and my best friend and her daughter drove Grace's things and dropped them in her dorm room and turned around and came home to have a funeral. The next day to get up for me and Grace to drive back to College Station to actually put her dorm room together. And I had to leave her that day, the day after his funeral, so she could start class at 8 a.m. the next morning. If you know anything about Grace, that was a dream that she had had. You went to school with her. Your friend's younger brother dated her through high school. It was a dream that she had most of her life, and she worked and worked and worked to get that. And she was so excited. In that first year, her time at A&M was so hard. Because she had on her. And Christian was everything to her. Her father wasn't there for her, but Christian was. Christian was the uncle that would send me a text saying, I rescued Grace from daycare, we're going fishing. He was the uncle that brought her a kayak for her 5th birthday to teach her to kayak in the back pond so she could go fishing with him. He was the uncle that did everything. He was the brother that was there for me for everything. And he didn't do things for me. He taught me how to do them. And he did things with me. And he was a son that showed up anytime his mother or father needed. We lost our sister when we were younger to cancer. And Christian was by her side. He was the person who gave to everyone. As Judge Stevens was talking about how we all need to help other people. That was the definition of who Christian was. Christian helped everyone. He was the guy that would pull over to change your tire. He was the guy that gave so much blood that after he died and I went in to start giving, they came to talk to me because they knew who I was, because Christian spent so much time giving blood that they even knew my nephew's name and asked how he was doing, because he spent so much time giving and doing for other people. I could go on. But I can't be angry. I can't carry any more anger. I can't. I know that as part of your agreement, it was asked them to not contact the family. And I know that was a wish that Amy and Hannah have had. But I invite you to talk to me. You should learn about who Christian was, because I think what you lacked in character the night of the accident, you could learn from learning about who Christian was. And I know your mother, and she was a good lady. So I know that she raised you to be better than you were that night. I know that's fair. I know you have that foundation. And I invite you to reach out to me and ask questions. Learn about him. Our lives will be connected for the rest of our lives because you got behind the wheel that night. Please take the time to learn about what you took and who he was so that you can grow and take the rest of your life to be more like him. Please. Thank you. I've written my speech on my phone. I've seen videos on social media of people reading letters like this and forth, but I never imagined that I would be writing one myself, and especially not at 19 years old, and especially not for someone that I love so deeply. Christian Michael Sykes, or Crick as we called him, was my stepfather, but he was more than that. He was the most generous, trusting, and loving person I've ever known. Crick has such an impact on my life that I now find myself grateful for parts of him in every new friendship I form, just to make sure that I'm surrounding myself with people like him. When I was 16, I was getting ready for bed at my dad's house in Austin when I got a call from my grandfather. He was so flustered that I couldn't understand what he was trying to say at first. He asked to speak to my dad, and when I finally was told, I sat on my bed repeating the words in my head. There was an accident, Judah's in the hospital, and I'm going to drive you back right now. 20 minutes later, I was in the car, and by then I already knew what Crick's name had to come with. At midnight, we pulled out of the gas station, and I cried in the passenger seat knowing I had just been told that Crick had been killed. For 4 hours, I sat in that car on the way to a house that could never feel like a home again. When I arrived, I walked into my mom and Crick's bedroom and saw my 5-year-old brother lying on Crick's side of the bed in a hospital gown. His hair was a tangled mess. His arms were scratched and bruised from his shoulders to his fingertips, and his face was flushed. And all I could do was lay next to him and hold him, thanking God that he was still with us, but at the same time asking why Crick wasn't. The day after the accident, I learned that someone I had never heard of left my family at the scene of an accident he caused so he wouldn't get caught. 4 days after, I turned 17 and opened birthday gifts from Crick without him. Weeks after, the world kept moving while I remained stuck on August 12th. Months after, I was hospitalized for my mental state. That December, we had a birthday party for someone who was no longer alive to celebrate it. A little over half a year after, I graduated high school without him. And a year passed and nothing had changed. Now, 2 years later, I can finally stand here and say everything I've been carrying with me since the day he died. Because the truth is, this loss isn't over. A few years from now, I'll graduate college without him. One day I'll get married without him. I'll raise his grandchildren without him. I'll watch my mother grow up without him, and I'll watch Jude grow up without him. And all of that is because of you. You, someone whose name is now carved into my memory. Someone who went to my school. Someone who knew my classmates. And someone who had enough mutual friends with me on Snapchat to send me a friend request. But you are also the same someone who took my stepfather from my life. And that is how I'll remember you for the rest of mine. And I want you to remember every single word that was said to you today for the rest of yours, because you did this.
Okay.
I took this picture about 2 weeks before the accident, and I want to show the people that can't be here that were most affected by this. Thought about what I wanted to say if I ever had this opportunity for over 2 years. And so many words have gone through my head. And now that I have the opportunity and tried to write it all out, I had no idea where to start. or if there's anything that I could even say to express how devastating experience has been to me, to my children, to all of Christian's family, and to all the people who loved him. And there were a lot of people who loved him. There are no words, although Hannah did a pretty good job, to explain the shock of being told that your husband's no longer alive. What it's like to try to process how that is possible, what it means, what you do next. It was a full 24 hours. Numerous phone calls and face-to-face meetings with various law enforcement personnel before I actually understood that my husband didn't die in an accident. My husband was killed because of somebody's choices. The reality of my life every single night for the last 2.5 years is to picture my husband lying on the side of the road and to hear my baby crying for his daddy. And to ache because I wasn't there. That's what's in my head. At night when I try to sleep, in the day when I try to teach my students, when I go home and try to hug my children, that's what's in my head now. So here's what I know. I know that Christian Sykes is a good man, made mistakes, and he has faults. But like Hannah said, he was a helper. He was the guy that everyone called, everyone. He was the guy that knew how to fix everything. And if he didn't, he would figure it out. He cared about the world. He cared about human beings. He cared about animals. He cared about the future. He wanted to make the world a better place. And I don't think he ever realized how much he did. He was a man who fixed people's cars and held open doors. But more than that, he was generous with his time, his knowledge, his possessions. And even more importantly, he treated people with respect. It was something that I always noticed about him long before we were a couple. He acknowledged the people that society ignores. He saw them and he set an example to others. And at his funeral, the custodian from my school came and I thanked him and told him he didn't have to be there. And all he said was, he always shook my hand. And that explains so much to me. Christian loved his niece immensely and unconditionally. He brought his stepfather into his life wholeheartedly and loved her completely. He had godchildren who he cared about so deeply. But becoming a father brought out a tenderness and a devotion that I can't describe. The love he and Jude had for each other was so deep, so pure, and so beautiful. They were truly each other's best friends. When Christian was taken out of all of these kids' lives, that loss was so huge. It affected them so much more deeply than I have the right or the words to express. You have no idea how much damage that caused. I wanted to talk about Christian as a husband. I wanted you to know all that was taken from me in that way, but
I can't. It is too personal and too special, and I will not dirty it by talking about it here. But what I can say is that from the time that Christian and I started dating until the day he died, I felt more seen, more loved, and more understood than at any other time in my life, and I cannot imagine that I will ever find that again. There's so much more. I considered telling you as many specific stories about Christian as I could. I thought about giving a list of the facts of his life. I thought about trying to list as many people he loved and who loved him as I could. But none of that seems to matter. But what I do need to say now is that I had to explain to a 7-year-old this past Friday what was going on. I had to tell him why his mother and his sister had been so emotional. I had to try to explain a court system that I don't understand and what was happening today. And I asked him if there was anything that he wanted to say. He said he just wanted to know why we can't all be a happy family, all 4 of us together again. I'm not sure if I will ever forgive you. I'm not sure if you deserve it, but I will try. It's not for you. It's because I only have so much energy to give. And I want all of it to go to something good. I want it to go to loving my babies, my husband, my family, my friends, my students. I'm not going to waste any of that energy on anything negative. That said, I truly hope that you have learned something, that you do better, that you find a way to do something really good in this world. Too much good has been taken out of it by your choices. And I truly hope that one day you have an opportunity to give some of it back. Thank you.
Yes, ma'am. Thanks, Jeff. Anything else? Sure. Thank you. All right. Obviously underscores the tragedy that we deal with, the tragedies that we deal with here in this courtroom often, but especially the difficulties we have to deal with when someone is operating a motor vehicle irresponsibly. And lives, when they're lost, it's obvious that their lives touch so many other people, loved ones, friends, and others. So what can we say, since we can't bring a life that is lost back, is to drive responsibly because lives depend upon it. All right. Anything else to add in this case by any of your parties? All right. Then, Mr. Dunham, you're taken into custody to begin the service of your sentence. We are in recess on this case. Here. Mr. Turk, you got some things?
Yes, sir.
All right, tell me when you're ready. I've got a Joe Culpepper.
State just came, not one judge.
You need to talk to them.
I do, I mean, probably, if you don't mind the category sick, because it's a TVCL for 5 years. So you need to see when you can watch it, because it's on the MTRP for failure to report one time, so
Your Honor, the last time we approached on this case, it was,
I need some of those dollars.
oh, sorry.
Okay.
The last time we were approached on this case, it was just a status hearing. He did not show up for the status hearing, and at that time you had requested that the state file the motion to revoke. So this is the first appearance now that the motion to revoke has been filed.
Where's Mr. Goldberg? He's in.
I haven't had a chance to tell you, I'm the officer judge. That's so we got
Once we call for, because if it's going to be taken, we're not going to wait on it.
I just haven't had a chance to talk to him.
Okay, all right. And I'll give you some time.
Yeah.
Um,
You want to do others or you want to go back and talk to him on that?
On Mr. Culpepper, I'm going to give him some time to talk to him, but if it's going to be resolvable, I want to resolve it today.
Okay.
Okay. And then I've got Christopher Dias, which is also Mr. Turks. Jacoby Fleming is Mr. Turks. 2 cases. John Guillory is on 2 cases. Jack McAllister is also Mr. Turks. Edward Porter. Yeah. It's also Mr. Turks. Then I have Adam Chavez with John West. And Matthew Smith is also John West. That's some of them. Bruce will be back. Giles on Kobe Broussard. Yes. Ready on that? Ready. All right. Let's get Mr. Broussard, Jacoby Broussard. Who's coming up? Chelsea. Two cases are called 24 CR 1726 and 1727, the state of Texas versus Jacoby Broussard. You are Mr. Broussard?
Yes.
Press with Mr. Cole, your attorney and the state's attorney. Earlier, you have entered pleas of guilty back in, looks like November. Pleas of guilty in 24 CR 1726. That's burglary of a habitation. And 24 CR 1727, the 3rd-degree felony of evading arrest or detention with a motor vehicle. And pre-sentence reports have been prepared in each of these 2 cases. Have the parties had an opportunity to review it? Are there any correction or changes to it? State?
Yes, and there are no changes, Judge.
And defense?
No changes necessary.
Then the pre-sentence report is made a part of the record for all purposes. And just a couple of things I wanted to.
Yeah, I'll be in the same years.
It looks, this is accurate. He has a felony conviction.
Yes.
Where he was placed on probation in Harris County. That was revoked. That was burglary of a habitation. Revoked in 2013 and sentenced to 4 years confinement. Is that accurate?
Yes.
Okay. And it looks like in 2015, you were sentenced out of Harris County, Texas for a misdemeanor of illegal possession of marijuana, and in 2019 for evading arrest or detention. Also, no, that's out of Hardin County, and these are two misdemeanors. A conviction and another conviction where you were placed on probation for 6 months, right?
Yes.
But that was a conviction, a regular probation. What happened in that? Well, did you serve that out?
Yes.
Yeah. So you got 2 misdemeanor convictions and then this one burglary of a habitation conviction out of Harris County for 2013, correct? Okay. And again, the agreements, whatever sentence shall not exceed a cap of 8 years imprisonment. So each of these, there's the 2nd-degree felony of burglary of a habitation and a 3rd-degree felony of evading arrest or detention in cause numbers 1726 and 1727 respectively. So we would be looking at imprisonment of no less than 2 nor more than 8 years confinement in each case. You could be sentenced to no less than 2 nor more than 8 years confinement in prison, and that could be suspended and you could be placed on regular probation in each case. And then the court can also defer any finding of guilt and place you on deferred or unadjudicated probation. Those probations options can also be a length of up to 10 years in probation. All right, the state may go first and last if you wish.
They get a racer.
I'll waive the opening, Judge.
Mr. Cole, on behalf of the defendant, go ahead. Go ahead. Sir. Yes, sir.
I'd like to call Ashley Kelly to the state.
That's going to be the complainant in the burglary, right? And also. Want to raise your right hand? Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Lower your hand and tell us your full name, please.
Ashley Kelly.
And
ASHLEIGH Kelly KELLY.
And how or what is your relationship with the defendant?
This is my husband.
Okay. How long have y'all been there?
Since 2019.
Okay, go ahead. Giles, when you're ready.
Ms. Kelly, once again, could you state your name for the record?
Ashley Kelly.
And how long have you known Jacoby Diesel?
We and Jacoby met in 2016. We had our first child in 2018. We got married in 2019.
And how would you describe your marriage relationship?
He has his ups and downs. Jacoby has shown me what a great husband, a real man. He's been a great father to all 3. He has a son. So we have 4 children together. He's been a great father, a great husband, and a provider.
You're living off of What is your current address at this time?
Prairie, 1879 Prairie Street.
So where were you living before you located to Fort Myers, Texas?
Orange.
You live in Orange?
Yes, sir. Orange.
How did you end up moving to?
We decided to relocate because of an incident that happened. Someone tried to break in.
Did Jacoby have anything to do with finding the location of the residence that you lived in?
You said what, sir?
Did he have anything to do with finding the residence?
Yes.
Could you explain to the court?
Pretty much, Jacoby is the sole provider, so he leads the way pretty much. So anything he says, he take the lead, I follow. He rode around and pretty much went from neighborhood to neighborhood. He felt like this was home for us, so that's what we went.
Jacoby, did he pay any bills at this residence?
Yes, he paid the bills since we've pretty much been together since 2016.
And I guess the question is, why wasn't he on the lease?
Because he's a truck driver, so he was over the road. So I signed the lease.
The day this incident occurred, there was a storm. Would you care to explain?
So pretty much we had already, pretty much every time we argue, it's about finances. I haven't had a job. Our youngest daughter, she just turned 5. So I haven't had a job that long, 5 years. I'm pretty much spoiled. So anything I want, need, parents, then Jacoby came along, he gonna provide. So he sometimes will tell me, hey, he don't fuss about it, but he'll be like, hey, I need you to get a job. Hey, the bills, I need help. And I just, I go online and try to put a few little job applications in here and there. And then I see, oh, the bills got paid, so it's not that big of a deal. So that's pretty much how that went. At one point, I guess that weekend, that whole week, we have been arguing, like I said, about finances. So Saturday, I went to my mom's in Silsby, and before I had left, he said that he needed help or he's gonna leave, and I'm, ungrateful, and another woman will be thankful to have a man like him. And so I said, well, go, because guess what? I have another man coming here tonight. So that's pretty much how that went. So the next day, still woke up, you still need help with finances. I'm still on, oh well, suck it up, buttercup. And that's how things went. Absolutely.
You asked him to leave, and did he leave?
Yes.
And when he tried to return to the residence, what happened?
He noticed that the key was gone.
And
I took the key off the day before. So this happened, I think, like on a Sunday. So when I went to my mom's in Silsby, I took the key off his key rings.
And were you aware of a hurricane that was blowing in the Gulf of Mexico around that time?
Yes.
You remember the name of the hurricane?
No, sir.
His name, Hurricane Beryl.
I don't know.
Okay. So, what would you like the court to do in this case?
I really didn't want to press charges, but from my understanding that the state had to pick it up, I don't want him to go to prison. I don't want him now probation for such a long period of time because, for one, we're married. For two, he's still in the same house that he kicked the door in. He's still paying the bills. He was paying the bills before. Even whenever he went to jail, he was still paying the bills. He was calling me, from jail. Then when he got out, he still went through his mom to tell me, hey, pay this bill, pay that bill, and so forth. He's been true to himself and his word. I'm making sure that me and his family are straight.
Me and you've talked a few times since that incident, and you said you noticed some changes in his attitude and his behavior.
Yes.
Explain to the court what have you noticed?
Well, we attempted to do marriage counseling through my church.
so far, any little thing in the past, any little thing could possibly irritate him. He does this thing where he likes to go fishing or he likes to go work out with his friends. So I think that that's a big help. And now that I'm on the verge of getting a job, I can kind of see the weight lifted off his shoulders, like he sees the light at the end of the tunnel. So I think that's a big deal.
So I guess you're telling me that he's more softer now?
Yes, sir.
And just to be clear, are you afraid of Jacoby?
No, not at all.
And you have minor kids that live at that house?
Yes. But our oldest, that's my stepson, he's 16. We just took him back to Houston yesterday. Our oldest is Alicia, she's 10. She's my daughter, that's his stepdaughter, but he's been in her life since she was about 7 months old. So that's all she knows. He doesn't treat her any differently. Then we have our middle child, which is Faye, she's 7. And then our youngest is Genesis, she's 5.
How does he interact with others?
Well, he works about 12 hours a day. So of course, when he comes in, he's a little tired, but that doesn't stop him. As soon as he comes in, they're gonna dump on him to get to the back. Even our dog, we got a little winged dog, and everybody is either barking or jumping on him, trying to get his attention. So as far as going outside and stuff, that's who goes outside. I stay in the house, I'm cooking, I'm cleaning. He's outside on hoverboards and stuff like that. The kids jumping on the trampoline and stuff like that.
Are you aware of his prior burglary rehabilitation?
Yes.
And what do you know about that?
That's from a passionate love crime.
That explains.
I just know that, she said certain things that led to that. I know that she was cheating. So she asked him to call her one day. I'm not sure if that's that specific day. And he was supposed to bring like pizza or chicken or something over. And then she changed her mind because he was already there. So, knocking on the door, no one answers, but when they do answer, it's the guy. She provoked him and her, the guy, and her provoked him. And, you kind of like, you bought my tickets because he was saving her money, pay her bills. She said she had a business trip. You gave her the money to do that. So, and it was to pay for another man. So of course your emotions will be high, you will be angry. Yes, he did not live there, but they lived together. His name wasn't on the list, they wasn't married. So I feel like our situation is good.
That's the issue.
Stay. All right. Ms. Kelly, when was the last time you and I talked?
That November.
That's the same day to the plea, right?
Yes, sir.
And Mr. Broussard's case was set on the trial docket. Yes or no?
Yes.
And you asked to speak with me about dropping the charges.
Yes, sir.
And do you remember us leaving the courtroom here, going to the witness waiting room?
Yes, sir.
Do you remember me talking to you about the facts of the offense?
Yes, sir.
And do you remember making a statement to me that as far as what you detailed in this statement, that all that was true and correct?
Yes.
Do you remember that?
Yes, sir.
And specifically, I gave you an opportunity to review what you had hand wrote out that day, where it says, I broke up with Jacoby. Jacoby packed his things and left the house around 5:30. He started calling my phone around 8, asking why did we break up. As I was on the phone with his mom, he came, kicked the door in, bedroom door in, and then started slamming me and punching me. All that? You wrote all that?
Yes, sir.
And you agree, when you and I talked, I confronted you with that, gave an opportunity to review it. You admitted all that was true.
Yes.
Today, you're telling the judge that you guys are married. Are you ceremonially married?
No, we went to Vegas and got married.
When was that?
2019, April, maybe 26th or something, 2019.
Why are your names different?
Because I haven't filed down here, I want to keep my names.
You haven't filed down here?
Yes,
What do you mean by that?
we're legally married, but when we came down here, we never went to go to the courthouse or whatever you're supposed to do down here.
Okay. So you're on the lease. He is not there at 1879 Prairie.
Yes, sir.
You kicked him out of the house, was your statement.
Yes,
You took his key,
yes,
yet he came back the next day and he broke into the house.
right. Because he's looking for his key.
Understand, but he broke into the house.
Yes,
Called 911. Yes?
yes, sir.
You told them about how that was happening. They heard it all occurring, heard you screaming as you broke through the door. You remember that?
Yes, sir.
You also gave the officers the ring camera that showed that he broke through there. Now, when this happened, ma'am, Mr. Broussard, that you're asking for probation, ripped the braid out of your hair. Yes?
Yes, but I feel like it's because my hair,
You have excuses, but he ripped the braid out of your hair. You had bruising on the right side of your face,
yes, sir.
as well as your right knee was scratched. And all this happened in front of one of your children by the name of Jensis.
Yes, sir.
Who wasn't quite 5 years old. And it was the whole reason why CPS was called out there. You told the judge that his prior was just where she provoked him. That prior occurred back on November 15, 2013, for the same type of offense where he burglarized a house with the intent to commit assault. Are you aware of that?
Yes, sir.
It's not just a burglary charge, it's the same actual incident that happened to you. Nothing stolen, doesn't have to happen on a burglary. But if somebody breaks into your house with the intent to assault you, that is a burglary of a habitation. You understand that?
Yes, sir.
So you said that Miss Patricia Claiborne provoked him? Yes?
From my understanding, I didn't go through that, so.
So that's him telling you that?
From me and her have a great relationship. We all go to birthday parties, vacation together, so.
Told the judge all this happened because you're spoiled. Are you aware that in this version of the PSI, the defendant, your husband, claimed that you made a provocative remark, meaning you provoked him? And that's the reason why he did it. He also says, ironically, that you're spoiled. Same thing that you said. Do you think any of those things justify what happened to you? Yes or no, ma'am? That's rhetorical. Let's move on. Were you the complainant in the offense that occurred on August 7th, 2020, assault causing bodily injury to a family member in Orange, Texas?
Me?
Were you the person that he was alleged to have assaulted? Were you that family member in Orange County?
I don't think so.
Were y'all living in Orange County in August of 2020?
Yes, sir.
You weren't aware that he got accused of that offense?
No, sir.
Is it possible that it was you and you just chose not to prosecute?
No, sir. I don't recall that.
Okay. Are you aware that the conditions of his bond requires that he not be in the same household with him? He can't have contact with you. The conditions of his release that allows him to walk around instead of being locked up back there is that he cannot be in contact with you. You're looking at me like you've never heard that. I told you that back in November.
November, you told me that if he get on probation and walk out of here, that he cannot be around me.
I also told you he couldn't be around you while he was on bond. You don't remember.
Whenever he got locked up the first time.
I'm talking about right now.
No, sir. I'm sorry, no. I thought you were talking about whenever he
No, ma'am.
went to jail and.
No, ma'am. No, ma'am. The standard condition of bond that this judge, hang on a second. This judge and the judge next door have a general condition of bond that a defendant may not be in contact with the victim of an offense. Makes no exception about whether or not you're married or not. That's so that the two cannot talk about how to resolve the case. That's not supposed to take place.
Yeah.
Y'all talked about this, obviously.
You talked about what?
This case.
How?
About how you want, you don't remember coming when we had that meeting and you told me you wanted to have the charges dropped?
Yes.
Y'all did not talk about that before that incident?
I'm the one who called you at your office to talk to you about this when I first got the paperwork sent to my house.
Yes, ma'am.
So I don't need to talk to Jacoby about anything. This is just coming truly from my heart.
Okay. And was that about your comment where you thought this wasn't a burglary?
Yes, sir.
Yeah, and you remember us explaining that to you?
Yes, you told me it's different shapes and forms. I just wanted y'all to understand that we're married and we live together, and I took things, I said things, the whole nine.
All right, so I'm glad you repeated that. When we had our conversation in November, do you remember me telling you it's not your fault what he chooses to do?
Yes, sir. Yes, sir.
And I told you that you don't need to blame yourself behind his actions.
Yes, sir.
Yet you're still saying those kind of things right now.
I guess it's because I try to put myself in his shoes. And if I pay all the bills at this house and you take my key, I come back to talk to you, but you took my key. What else am I supposed to do? When you just told me yesterday and this whole week how you have this girl or this guy in and out the house.
I have no further questions of her, Judge.
Right. Anything else? Guys, anything else?
Questions, Judge?
What's next?
So I do call
it. His mother.
His Bruce Oda.
All right, raise your right hand, man. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Go ahead.
Could you state your name out here for the record?
Thank you, Bruce. All right.
Ms. Broussard, you've been around Jacoby and Ashley, who've been married. What are the dynamics of their relationship?
I know.
I'm going to object to the relevance of that, Judge.
Okay.
What her opinion about their relationship has no bearing on the sentence.
Okay.
What would you ask the judge today to do on this case?
Your Honor, I stand before you. Yes, I am the mother of Jacoby. Yes, he's made some mistakes along the way. The person that paper says is not the person that I raised or my mother helped me raise, and my father. Jacoby is a very hard worker. He's dedicated to helping people. I can go back to when my mother and father had to raise my nieces and nephews. Jacoby was in middle school. He was just a little boy. He had to help my mother and father because I didn't leave home until I was 27 years old. I had Jacoby early. So staying at home, Jacoby helped my mother and father with my nieces and nephews while my sister was out in the world. From changing diapers to making bottles, to helping out whenever he can, putting kids on the bus and getting them off the bus when he got off the bus. So Jacoby being the person that paper says he is now, that's not the person who I raised or my parents helped me raise. Jacoby, I looked at before he graduated, I was going through a divorce. Jacoby went on and took a job, 2 jobs, to help me put him through college. Jacoby did 3 years of college. He got his son's mother, they had their son. He had to drop out of college. He dropped out of college and took on truck drive. That's how he got truck drive. Jacoby worked after he graduated. Like I said, he had 2 jobs. He worked himself to help me put him through college and almost had a light heat stroke. At the time, I was taking care of my mother in my apartment in Beaumont. He had to help. He come home full sweat. Fall. We called 911. They told me he had a light heat stroke. He stayed in the hospital a week. He got out, still helping me with my mother, that I was taking care of at the time in Beaumont. We're gonna fast forward, Judge, to when he had his incident in Houston. That was hurting. Yes, he knows the severity of what he done then and what happened with him and his wife now. At the time, his son's mother, high school sweetheart, cheated. All he knew was her. He took care of his kid, dropped out of college so he could pursue truck driving so he could help take care of his son. And that happened to him. That's strike number 1.
We're talking about the burglary of a
Yes, sir.
habitation
And
in Harris County in 12. Now, he was given a chance, right? He was placed on probation.
Yes, sir, he was given a chance.
Hold on, let me speak and then you can.
Yes,
She
sir.
can't she has to take everything down.
I'm sorry.
We speak over. See, when we speak over each other, she can't do it. And actually, the courts have said she's the most important person here because if they review these proceedings, they have the record. And if she can't make a record, then people get in trouble. And
Yes, sir.
it's not going to be me. But he was placed on probation in 2012 for burglary of a habitation. And then a year later, that was revoked. And then he was sentenced to prison.
Yes, sir.
Okay. All right.
It was provoked because when he got out, his son's mother was sending him bus tickets to come down there so they could rekindle.
Okay, but it was revoked because he was required by oath to honor conditions of probation.
Yes, sir.
He did not.
He did not.
This is a solo, and then you'll get to talk. He did not. So he, number one, committed a crime that was given a second chance. Number two, he then failed to honor the requirements that the court had, and he was revoked and then sentenced to prison. That's that one. Question is, what did he fail to learn from that event where he was placed on probation? Because here we are, he's charged with burglary of a habitation and evading arrest or detention with a motor vehicle. You're supposed to learn lessons to better yourself and not commit the same crimes again, right?
Yes, sir.
So what happened in this?
Well,
I know I'm looking at the probable cause affidavit. I know what the facts are, but why? You touch the stove, you know it's hot. You don't touch that stove again. He is now embracing the hot stove. It's almost as though this is okay. I've done this before. I've been punished, but I know I'm going to get punished again. So I'm going to grab the stove and hug it. Rhetorically, I'm speaking, but it's the same type of offense. Again, how do you explain that?
you know, Judge, we've all made mistakes along the way. And
I've never made felonies.
no, I've never
Or misdemeanors that I'm aware of.
Absolutely.
But it's not that hard to follow the rules. Live honestly. Give each person respect.
You're absolutely right, sir.
Don't harm others. Those are the three basic components of all the law we have.
I understand.
He violated all three of those at least twice.
Well, sir, me being the mother,
I understand.
that,
I understand.
and I'm not
I know my
gonna
mother,
take up
I know
for-
my mother would,
I'm not gonna ever take up for Jacoby because I work in a position where I see offenders every day.
yes, ma'am.
So do you want your son to be there? No, but if he,
You want your friend to
I want
make the
him to
right
live a
choices.
successful life, make the best choices,
Yes.
the correct choices. Well, I'm not gonna ever, he can explain, I don't ever take up for him. If I have to
Well, he's
knock
an
him on the
adult.
head.
He's got to be responsible for his own.
Yes, sir, he does.
But just like all of us.
Yes, sir. So I stand here before you today, Judge. I understand the severity of what he has done in the past and now. And, you know, I want the best for my son. He does love his kids. He takes care of his kids. He's not out, you know, stealing, robbing, doing none of that. Hey, he goes to work every day.
What's the greatest gift you can give to your child?
Love.
A good example.
And me.
Role modeling. They're going to do just what you do.
And
so what do we say about the children, his children, when they start burglarizing homes or possessing drugs? Dad did it.
But Dad learned.
What's wrong?
Mistake.
I mean, how can the kids? Dad did it. I love Dad. He's my role model.
I understand, Judge.
Oh, those are, again, our life touches others, not just ours, touches others. And the father is going to be a direct influence to children.
Yes, sir.
So, what I worry about.
Well, I feel the person that he is now, his kids, he's a role model to them. What they've never seen him do any drugs. All they know is Dad goes to work early in the morning. Dad comes home and he takes some time with him. Same thing I do. Same thing my parents taught me. They taught him also because they helped me raise him. I've worked 27 years for the state of Texas and still there. So I'm a firm believer of working, and Jacoby is too. Jacoby started working at 15 years old and has been working ever since.
So why does he keep making these mistakes? Is the question. What's such a great?
If it was, I'm gonna put myself in his situation. Yeah. And if it was me, love, I've been in love, been married. Yeah. Have I done some things? Probably just hadn't got caught, Judge.
You know, but hold on here. This is the facts here. Let's see. He kicks in the front door, grabs her, throws her to the ground, begins to strike her with a closed fist. They see injuries to her face and knee. Then, after he assaults Kelly, he flees the scene. Guilty men flee when no man pursueth, but the righteous stand bold as a lion. He fled. You know where that's found? Book of Proverbs, Old Testament. So you can't debate that.
No, sir.
And sure enough, they have to chase him until he's finally apprehended. Well, that's after he's been convicted 3 times. Possession and one of those is evading arrest and detention. He's doing the same thing. It's like he didn't arrest less than the first time. And then the burglary, placed on probation, revoked, and here we are. But I've been married 40 plus years. I've never struck sizes. Never struck anybody. Any first female. It's just, I wouldn't even, it's just against the code of honor. I don't know how anybody even thinks to do that. And it's certainly not. Man,
You know, Judge, when you're put in a position where you love someone, huh?
everybody, hold on, I'm gonna stop you right there. We got good times and bad times, all of this. And you have to rise and you don't strive.
You're absolutely right.
You just know that's so small.
You're absolutely.
Especially someone that you pledged love to. I can't understand that. That defies any logic. But here we are.
Yes.
And you're asking for me to give it another chance.
Yes, sir.
I understand. And it's noted, and I appreciate your service, by the way.
Yes, sir.
To the government. Thank you. Anything else?
No further.
That is, okay. Did you have any?
I have no questions.
All right, thank you, Matt. I think I understand where we are. Okay. Anything else?
Second speak to my client.
Sir? Yes, sir. Go ahead and remember, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Lower your hands. Go ahead and
Say your name loud and clear for the court reporter.
and you are the defendant in this case. Okay.
Jacoby, you heard Texas mention the wife.
God bless you.
You've had a prior burglary of habitation. You're currently facing burglary of habitation in this case, and Vegas.
Yes.
I want you to explain to the judge your mindset why he should give you this opportunity to remain free and to continue to be a husband and to provide for your family.
Okay. Yes, so she can hear. You kind of trailed off.
Sorry to be a husband. Right.
Okay, can I go back to the charge?
Just answer his questions, however you need to.
Okay, can you say it? Repeat.
What was your mistake that night that incident occurred here recently?
That night, going back to the house, the night of the hurricane, riding on paper clothes left, trying to get a hold of her, trying to talk to her.
You said the night of the hurricane?
Yeah, the night of the hurricane. That night of the incident, it was the hurricane that night.
So you're in the middle of a hurricane?
Yes, I'm riding around in my vehicle. Trying to go back home. That was my mistake. Go back to the home. You know what I mean? I could have just, I guess, if it went to a truck stop, something like that. But going back there, that was the main mistake right there. Going back. Trying to get her on the phone to talk to me. So going back to there, right there in the heat of the moment, that was the main mistake right there.
And have you learned your lesson? I guess it's what the board is trying to figure out is what if he was to put you on probation, what has changed?
My prior charge, more of a man, a father to my kids. I'm married in the home. The previous burglary habitation, we were living together. She moved out 2 days after I go. She tell me to come see my son. Then I get there, and then she's like, wait, no, don't. That burglary, I can understand. I can understand. I wasn't on it. I wasn't even there living. 2 days after we living together, she has her own apartment. I'm in the home here. You know what I'm saying? On paper, it looks like I break into houses or something like. That's not the case. I live there. I pay bills there. This is where my family is, my wife, my kids, the whole nine. That night of entering into the home where I live, you know what I'm saying? The intent wasn't to beat her or anything like that. That wasn't my intent.
don't think of me as, oh, I'm just going to be the person. No, that's never my intentions. Not ever.
What were your intentions?
My intentions were to speak to her, but it was totally chaos. Once I realized that my key was gone and the things that were said to me, I got another man in here, all of that, the whole event. That's what the explosion is. Imagine you're paying your bills, taking care of your family, you get told to leave, and then you go home, you're riding around, and you go home and like, man, my key go. You know what I mean? When emotions are high, I guess my logic was low. Logic was low at the time. I don't break it. I don't get into trouble. I don't kick door. I go to work every day. So if you're looking at me as a burglar or something, that's not the case at all.
Well, hold on. You got convicted of that.
I understand that, sir, but
what's wrong? You either are or not.
When I look at a burglar,
hold on. You pleaded guilty in that first case.
Yes.
And the judge gave you a chance. Then you failed and it was revoked.
Yes.
You were found guilty and sentenced.
Yeah.
You were found guilty. You didn't appeal that.
Right.
It's fine. So don't say you're not a burglar. You were convicted of it. And here we are now. For another burglar.
How old were you at the time of that first incident?
Early 20s.
So why would you be a good candidate for probation this time? Why would you fail this time?
I'm a great father. My kids mean the world. My wife means the world to me. Continue to be the dad that I am, the husband that I am. For me, I'm not with that paper, with the charges and everything. I'm not that person.
Are you willing to go to mandatory marital counseling?
Marital counseling, whatever needs, whatever classes you guys need to see, I will attend, I've completed probation before, out of order for 6 months. Whatever's asked of me, I've always done it.
What happens right now if the judge was to remove you out of the house and incarcerate you? What would happen to your family?
Devastation. I'm the only problem. I'm the sole provider for my family. My wife does it things. So everything from clothing, from food, entertainment. We just got wrecked in October on Halloween. Had to get another vehicle. Everything. My kids go down. My wife go down. My household. She had probably had to move out. I don't even know what would happen.
But you just know it'd be.
Wait.
Totally devastation.
Wait. Whose fault is this? Why are we here? Whose fault is all of this? You're talking about what's going to be happening, how your family's going to fall apart. I'm sorry. I'm asking you, whose fault is it you pleaded guilty under oath to another burden? Okay, don't be talking about giving everybody else guilt a complex. You're the problem. You shouldn't be here again. You shouldn't be committing crimes. No, you get punished when you commit offenses. You've been convicted 3 times, and here we are, a fourth crime. Don't be giving us the guilt trip. This is your responsibility. You're here, not because of anything we've done, what you've done.
Yes, sir.
It's about time you started at this late date accepting responsibility and carrying out responsibility.
Yes,
not coming back to court.
Yes.
No.
Are you prepared to do that?
Yes.
Do you think you could benefit from any kind of veterans intervention program?
Yes, sir.
And things that help you search out other ways to communicate and take out your frustrations.
Yes, sir.
I passed the witness.
I'm a little confused about something. Right now, the relationship with you and the victim.
Yes.
What is it?
That's my wife.
I know what you're saying.
Yes.
How long have y'all been married?
Since 2019.
Oh, okay. And where have you been? You've been out on bond almost.
Yes.
Where have you been living? Where did you live last night? Where did you sleep?
At my home.
At your home with
yes.
Y'all. Okay. This marriage, it's a ceremonious marriage.
Yes.
You were married when?
In Vegas, 2019. A couple of days after our birthday.
You don't know the date.
2019. April 24th,
I bet your wife
2019.
knows.
Say that again?
I bet your wife knows.
Oh, yeah.
It's an anniversary. You're supposed to celebrate it.
April 24th, 2019.
And to think about it.
Yes. Under the circumstances, sir,
I understand. But you don't want to hesitate on that.
Yes, sir.
That'll just roll off the tongue.
Yes.
It's important.
Yes.
In front of the wife.
Yes.
State.
Let me affirm with you, Mr. Broussard. According to the PSI report, you told our CSO officer Riley there that y'all separated for approximately 1 month before resuming your cohabitation. Is that timeframe correct? So when you were arrested on July 7th, 2024, my information indicates that you were served with an emergency protective order that lasted for a minimum of 60 days.
Mm-hmm.
Is that correct?
Yes.
Really, the only additional question I want to ask before I make argument, Judge.
Is that it?
That's it. That's the only question I needed clarification on before I argue.
What are your positions, gentlemen?
Your Honor, Mr. Broussard was around 23, 24, first burglary of habitation. The facts in this case, he is married to Miss Ashley. They do have kids together. He's not perfect, but he has a lot of good stuff. It's rare that you find someone that has maintained a career as long as he has in the same particular field. There's no drug issues here. He rarely drinks. He can afford to pay his probation fees. The plaintiff, she is supporting a probation recommendation as well as his mom. He just needs a little help, Judge, and I think helping him isn't putting him in prison and he loses everything that he's worked for. If we want to help him, we can help him by putting him in a program where he can get the tools necessary to learn how to conduct himself when stressful situations occur. But being a man out here and you're paying all the bills, you don't do anything for yourself. It's a hurricane. Your keys off your keychain. You can't get in your house. Yes, he imploded. And the way he acted was wrong. However, he's done a lot of good too. And everything ain't about, locking him up because him and his wife made poor decisions on both ends that day. But what they've showed is that they're still together. They continue to be together. They're raising their family and they've moved on. Holding him accountable is, hey, if he's on deferred probation, the state still can go up to the full brunt of the law. If he steps out of line and he continues to be the man that he is right now. I'm not saying he's all the way clean. He got some termites under his rug, but who doesn't? All he needs is a little help. And I think that the probation, he's never had that opportunity. He had it he did have it and it was revoked, but he was 24. At the age of 37, I think he understands the seriousness of it.
24, he was an adult for 6 years.
Well, he was, Judge, but he's a young adult. He's an old adult.
He's matriculating into adulthood slower.
That's right. But I think he's there now. But I think that the state has enough resources to help him outside of the prison system. And so I just think for the better interest of society and for this family right here, he needs to remain free so he can continue on to pay taxes and take care of his kids and raise his kids. Because if you remove him out the house, then we got teenage son who's running rampant, doesn't have no supervision, and kids. And who knows where she's going to live. So there's a lot more that is at stake. If he's to go away, then if he was to stay. And that's my argument to the court. That he deserves to be in jail. Anger management. He can do community service hours. Hold his feet to the fire for 10 years, however long you feel is necessary. Let him prove it up. But to take him away for any amount of time right now will be destroying the nucleus of the family. And considering that they're still together and they're going to be together, it doesn't look like she's leaving anytime soon.
Go ahead, Steve.
November 17th, when this agreement was fashioned, the cap agreement here was me changing the prison time offer that I had. And it was honoring my word to Miss Kelly to give them an opportunity to come in here and have this argument that we're doing. I told Miss Kelly that day, and I'm going to tell you, Your Honor, that what this man did that day to her was never warranted. We've heard comments that he's a good man, that he's provided all these things. A man does not do what happened to that lady on that day. There's no excuse. There's no conduct that warrants saying she did something wrong. It is that lets people that are victimized like this get to the point where they won't want to come to court. And that is nothing that Miss Kelly and I haven't already talked about. We talked about that in November, face to face. I told her that she did nothing wrong, that she needed to quit blaming herself, that she had to break this cycle of violence. She does not recall that part of the reason why we were all having that conversation was that they walked in violation of the bond conditions, and I was telling her that. And they still are, blatantly. Someone who's learned a lesson and is ready to show this court that they're remorseful, that they can change their ways. He hasn't. He's just continued to manipulate everybody around and put her in a position to where she still today blames herself. Yes, I'm a little excited about it because the problem is this is why we have a repetitive cycle of domestic violence. Mr. Broussard needs to go to prison. What he did to this lady back in 2013, he's still blaming her today, just like he's trying to blame Miss Kelly. How do we fix that? We don't. The motion aside, he didn't follow the motion to revoke the probation he was given before. He didn't follow the conditions of the emergency protective order that he was given in 24. And he hasn't followed your rules as far as bond conditions are concerned. Why in the world should I believe in any fashion that he could follow rules of probation? The state suggests 8 years TDC.
Anything else? Ooh, sir, this is your chance. Mr. Broussard, anything you want to add?
Sir, I'm not a bad person.
We're judged by our actions.
I understand that.
You've got 3 convictions and a 4th one on the verge.
Yes, sir.
That defines good versus evil. That defines bad choices. How do you fix bad choices?
doing better.
You're employed now.
Yes,
When do you work?
I work every day.
What's that, 7 days a week?
Yes, sir, pretty much. As a truck driver, you can only drive legally so many hours a day. No, typically work 6 days a week, sir. I have 1 day off.
And how long have you been working there?
I've been there 3 years now.
Anything else? Fine. Okay, in each of these cases, the court makes the following findings. The defendant has pleaded guilty to the third-degree felony of evading arrest or detention with a motor vehicle in 24 CR 1727. That is third-degree felony. And he's also pleaded guilty in 24 CR 1726, and that is the second-degree felony of burglary of a habitation. The defendant has pleaded guilty in each of these cases voluntarily, knowingly, intelligently. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 admitted in each of these hearings to find him guilty beyond a reasonable doubt in each of these cases. And the court hereby now finds you guilty beyond a reasonable doubt in these two cases of burglary of a habitation and evading arrest or detention with a motor vehicle. The agreements fashioned in each of these cases is that you would be sentenced, and it states a cap of 8 years imprisonment. We talked about this. You're looking at no less than 2, no more than 8 years confinement in prison. That's one option in one or each of these cases. Then you could be found guilty, sentenced up to 8 years imprisonment. That could be suspended, and you could be placed on regular probation for up to 10 years on each of these cases. And finally, you can be placed on deferred or unadjudicated probation for up to 10 years. Those are the options here. You have been found guilty beyond a reasonable doubt. Deferred is not an option because of your criminal history. I am sentencing you to 8 years confinement on each of these cases to run concurrently. Just want that to sink in for just a moment. The court is going to suspend those sentences and place you on regular probation for 10 years. In spite of the wise words of the state, the court is factoring in what I believe is free will of the married parties here, in spite of the actions. I've never struck my wife. I never even think about it. I wouldn't curse the lady. I mean, you're supposed to be devoted, to cherish, to honor your spouse, which you don't do. And you're missing a great part of the relationship because you're supposed to be a better person by honoring the commitments to someone you love. You have been before courts far too many times with bad choices. And here, this relationship, I sometimes am put in a position of having to get involved in a relationship. I prefer the two people involved. If there are two people, generally, the two people involved work this issue out. Your wife wants this to continue. You say you do. You just don't act as though you do. But the other issue is this. I can sentence you to a term of confinement of up to 180 days as a condition of probation. How does that work with your job? Probably poorly.
Yes.
Yes.
Well, you're going to go to jail for a while. Now, I'll work around that, but I can put you on weekends where you have to check in on or before 6 o'clock on Friday, then they release you. On or before 6 o'clock on Sunday night, PM. But you're gonna have to work that out.
Okay.
You're going to be, I'm going to sentence you to a term of confinement of 180 days. I will consider how you perform to shorten that for appropriate behavior. But just know 180 days are 90 weekends. That's a long time. But you put yourself into this dilemma and your family in this dilemma by your actions, which have been irresponsible.
Judge, will this be consecutive weekends or?
Yes.
That is.
He's gonna have to work it out.
Almost impossible.
Yeah. Figure it out. He's put himself in a mess. You got to figure it out and work it out. And I'll work with you on that. But this is orders of the court. Speak, people. You're responsible for this. Yeah. One set. We're going to cancel those. Yeah, said here, I think I've got to sign on the evading arrest.
When will you be in jail time begin?
We can even arrange that. The weekends beginning on Fridays. When can you start that? When can you start the weekends beginning on Fridays at 6?
Sooner
the better. Sooner it starts, sooner it ends. But what do you say?
Whatever you see fit, sir. Whatever I haven't worked out with my job, I'll let them know today. What's going on? Will that be Friday the 9th?
That's what it adds up to. Let me know if you can't do it this week, beginning this week. And we'll see how he does. If it does well, we'll be rewarded. You understand what has happened today, sir, and the seriousness of all of this?
Yes.
Just don't. You're supposed to take the vows of marriage responsibly, accurately, which means you don't harm the person you pledge love to. Because it makes me wonder what you would do to somebody that aggravates you, who you're not in love with,
Yes.
is see this probation officer and begin your probation. That is something.
Yeah.
Yes, see.
Thank you, appreciate it.
Okay. Brent, and you got something too?
Yeah, wait.
Okay, Brent, do you have anything?
Please.
All right. Please or please?
Both.
Which please? How many do you have? One. Come on up. Let me take Mr. Smith real quick and then we'll get the Brents.
All that's it, and I'll leave. She's fine.
Client comes, her.
Yes, please.
First.
The certificate.
The Joseph. Yes, sir.
Cheers.
Thank you.
Brian. Favorite weekend. Where workers from the pool here, stuff you got?
Yes.
Okay, keep up your right thumb front. Place it flat right there.
Are you looking for this?
And
On the trial document, Mr. Bryant's on the trial document.
And then place right here, just tap, don't roll it. Okay. Okay, that, you go stand in front of judge.
Second page of it.
I think I may have given you the file docket, but
Oh.
since we now call.
He may be on the first page. I'm sorry, I'm on somebody
Your
else's.
final what's your final?
Let's do the first page. Since he's not on the second page, I'll go with the first page.
Mr. Bryant. So that is you, sir. Okay. We now call cause number 23-41373, the state of Texas versus Elvis Joseph Bryant Jr. present with Mr. Smith. Bruce Smith, his attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about September 12th, 2021 in Jefferson County, Texas, you committed the third-degree felony of injury to a child. You understand what you're charged with here, sir?
Yes, Your Honor.
Let me see if I can read this here.
So let's include the class A assault. So we're just taking out the child part.
All right, once again, you're charged with third-degree felony of injury to a child. An agreement has been reached between the parties that you would be pleading guilty to the Class A misdemeanor, lesser included assault, which carries with it up to 1 year in the county jail and or fine up to $4,000. Do you understand what the plan is?
Yes, Your Honor.
And the punishment range that is applicable here?
Yes, Your Honor.
An agreement's been reached, you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this charge? Guilty or not guilty? The lesser included Class A misdemeanor?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
Going to show you what's marked as State's Exhibit 1 that you need to sign. That's a bad thing. Yes.
If I could do this without putting my hand on it.
Yeah, don't touch it. It'll start a. It'll fire off a missile from NASA. No. Did you understand the contents? You signed that. Is everything true and correct in State's Exhibit 1?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses such as this Class A misdemeanor of assault. You were giving up your rights to a jury trial and the rights to the appearance, cross-examination, and confrontation of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states, so help you God. States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm making the following findings: that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of assault. I can find you guilty, but I'm going to follow this agreement and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. And there will be something concerning an anger management issue that needs to be followed, and a program that will be structured around that, and other conditions. Make sure you follow them. If you fail, your probation can be revoked, found guilty, and sentenced up to 1 year in jail. Please see the probation officer. Thank you. Brent?
And yes, it has one off the trial or Robbie Kelly. And Mr. Kelly needs to come in front of me.
See.
Raise your right hand, you swear or confess with the whole truth and do something about it. Okay, so your right hand print. You sit flat right down. Yeah. Off the black.
Did you order one?
Okay.
No.
Okay. Well, you don't mind it. One up behind. See. Next week. That's good. Why?
And your name, sir?
Robbie Kelly, sir.
This is off the trial docket, Judge.
All right, we now call 25 CR 1313, the state of Texas versus Robbie Lee Kelly Jr. That is you?
Yes, sir.
Present with your attorney, Mr. Turpin, the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment, sir, in 25 CR 13 alleges that on or about September 25th, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you were charged with?
I do, sir.
If convicted of a state jail felony, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty. Sentenced to 2 years in the state jail, that would be suspended. You would be placed on regular probation for 5 years. Restitution would be owed in the amount of $10,800 and other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. You understand? How do you plead to this, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked for State's Exhibit 1 there. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents true and correct?
I did, sir.
State's Exhibit 1 is tendered intact.
No, sir.
Without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 was made a part of the record for all purposes. Pre-sentence report is blank.
Yes, sir.
I will find in the record that all of those statements the court has just made in regards to State's Exhibit 1 and its admission are applied as findings of the court in this case. That is enough to find you guilty beyond a reasonable doubt of this state jail felony of burglary of a building. I now find you guilty beyond a reasonable doubt of this crime. I am following this agreement. You are hereby sentenced to confinement in the state jail for a term of 2 years. And I make this finding beyond a reasonable doubt. That 2-year term will be suspended. You are placed on regular probation for 5 years. There will be terms and conditions of probation, which are normally customary for a burglary of a building as or crime as in this case. You must pay restitution in the amount of $10,800. And this is going to go to the owner, William Spector, as the indictment alleges. I'm interested in what your plan is in getting him paid back as soon as possible.
Yes, sir.
What is it?
I'll make monthly payments, sir.
How much can you make?
I would say 250 a month at least. I'm on a salary pay, so I'll be able to adjust it.
Is 250 what you can do?
Yes, sir.
All right. You'll be ordered to pay a minimum of $250 per month, which will be applied to restitution in this case to the victim. And anything else to add on this? And please see the probation officer.
Thank you.
Good luck. Next. Who's next?
So they're going to receive some. Mr. Fleming is a plea. Mr. McCowell shares a plea, and so is Mr. Fleming. Yes, ma'am.
You probably do
2 cases.
2 cases. What we're going to be doing on Culpepper? What are you going to do on Culpepper? Right. See her. What are we going to do on Culpepper?
Judge, my understanding is the formation in the state or agreement to continue with the higher of the case.
It's my choice.
Well, that's right. Yes, Judge. Wasn't trying to be presumptuous, but that's the discussions we had. He,
No, you're right.
he showed up a day with us. He had talked to either Lacey or Ellie or one of the neighbors, and he just had the wrong time. It was. That's what it was.
2 cases are now called. The state of Texas versus Jacoby Fleming. That's you, sir?
Yes, sir.
You were here with your attorney, Mr. Turk, and the state's attorney. Does the defendant waive formal readings of 24 CR 1565 and 24 CR 1892? Can we proceed in summary?
Yes, Judge.
In summary, cause number 24 CR 1565, that indictment alleges that on or about June 13th, 2024 in Jefferson County, Texas, you committed the 2nd-degree felony of robbery. Do you understand what you're charged with there?
Yes, sir.
We're looking at, if convicted, no less than 2, nor more than 20 years confinement, and a fine up to $10,000 can be assessed for a 2nd-degree felony. Do you understand what you are facing?
Yes, sir.
An agreement's been reached in your case You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. Is there any restitution?
No, Your Honor.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty? That's a question.
Yes, sir. Yes.
Hold that one in abeyance for just a second and go. The next case, which is 24 CR 1892. In summary, this indictment alleges that on or about July 31st, 2024 in Jefferson County, Texas, you committed the third-degree felony of harassment of a public servant. And that is, while confined in the county jail, you harassed another person by, it looks like, spitting upon that person. You understand that you're charged with?
Yes, sir.
This is a third-degree felony, which means if convicted, you face no more than 10 years in prison or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended and you would be placed on regular probation, similar to the previous case. And those two cases would run concurrently. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this case? Guilty or not guilty? I'm sorry.
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
No. You see that color, which is.
Pads are not working any faster than they did before the holiday. I show you what's marked in each of these cases as State's Exhibit 1. Did you sign those documents? In each case voluntarily, understand them, discuss them with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence.
Objection.
Without objection, admitted. And for each of these cases, this all shows you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictments and read to you. You've read them. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer in each of these cases. So help you God.
Yes, sir.
Exhibit 1 is made part of the record in each case. Go ahead.
With regard to the competency,
I'm going to.
okay, yes, sir.
In each of these cases, we have received information by letters dated December 2nd, 2025 for each of these cases that the defendant was admitted to the University of Texas Health Sciences Center at Houston based upon Article 46B.073 of the Texas Code of Criminal Procedure regarding a finding of non-competence to stand trial on these two cases. And after medication and medical reevaluation and treatment, it is deemed by the University of Texas Health Sciences Center in Houston, the treating entity of this defendant, that the defendant is now competent to stand trial. And these reports which the court will refer to as Courts Exhibit 1 in each of these cases will be made a part of the record for all purposes. Any objection by the parties?
None from the state, Judge.
Anything that's said, you know, when you used to get sweet.
They made a part in each of these two cases. And again, pre-sentence reports are waived.
Yes, Judge.
All right. In each of these cases, the court is going to find that the defendant has pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in each of these cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. Again, the 1565, the second degree felony of robbery, and in 1892, third degree felony of harassment of a public servant. You're found guilty beyond a reasonable doubt in each case. In following these agreements, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years in each case to run concurrently. Those sentences of confinement shall be suspended. You are placed on regular probation for 10 years in each case to run concurrently. There will be terms and conditions of probation that you will follow. The probation officer is going to go over those with you. Make sure you follow those. If you fail, the probation could be revoked. You could then be sentenced to no less than 2, no more than 10 years confinement in prison. So it's important you follow those. Do you understand what has happened today, sir?
Yes, I see you right now.
Yeah, you're going to go see this person. I'm going to sign these documents and then you will begin probation. Yes, I'll do it. This must be what hell is like, a never-ending signing of documents.
I think Dante wrote about that, Jeff.
Okay, here we go. Thank you. Thank you. Next, Jack McAllister. Yes, sir. Jack McAllister, please.
Yeah. We have Mr. Judge, is it a state jail punished as a second degree? So. If I didn't, my apologies, I'm gonna do it, but because the intent. This more. So we have. No, yeah, sorry. Go over to the top, that was.
Ms. McAllister, please raise your right hand, please swear at once. Have a visual group on the three fifty God. Ink up your right thumb print. Place it flat right there.
Should be 4 years TDC.
Ink it up one more time.
I think that's.
Place it flat right there.
If I did it, that's what I'm saying. Since I wasn't sure. We'll make sure I did the correct paper. So it's 4 years TDC.
Good. Are we getting new pants soon? Because
I'll call to get an update today.
I'm writing and it takes about, I write something and it takes about 10 seconds for it to show up.
Yes, the same issue as me.
Okay, it's fine. All right, 25 CR 1356 is called. State of Texas versus Jack Marvin McAllister. Is that you, sir?
Yes, sir.
Present. With your attorney, Mr. Turk, and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
What are we going on? Which?
I think you have to go in all
three paragraphs
to get them forward.
All right.
We have about 2 pages.
In summary, paragraph 1 alleges that on or about May 23rd, 2025 in Jefferson County, Texas, you committed the offense of tampering with an electronic monitoring device, a state jail felony. Do you understand what you're charged with here? Paragraph 2 goes on to allege that you, on August 9th, 2015, in the 29th District Court of Palo Pinto County, Texas, you were convicted of the felony of online solicitation of a minor. And it says online solicitation minor sex conduct dash second degree on August 9th, 2015, and cause number 15641. Do you understand what you're charged with in that?
Yes.
Paragraph 3 goes on to allege that after that offense, online solicitation of a minor, in paragraph 2 was final. It states that you committed the felony of failing to comply with sex offender registration duties, a third degree felony, and were finally convicted of that offense on August 21st, 2021, out of the 294th District Court of Van Zant County, Texas. Do you understand what you're charged with in paragraph 3? Okay, so being found guilty and true beyond a reasonable doubt to paragraphs 2 and 3, and guilty of paragraph 1, constitutes a state jail felony, punished though as though it were a second degree felony, right?
I mean, something that period or something.
I'm not sure this is right here. Because there needs to be something.
I don't like this.
It's got the range of punishment, which is for a second degree felony, but that's not.
Well, up in the
accurate.
corner, I put it, I noted it was enhanced to a second degree too.
Where's that?
Up in the right hand corner, Judge. Upper right hand corner.
Where?
I'm sorry, let me know.
This says,
Enhanced second 2 to 20. I was trying to.
you're gonna do it.
Okay. Like I said, Judge, I didn't
The
like.
word enhanced is not in there and it's in H2 2-20, which doesn't give anybody. So.
Like I was saying, the forms, I don't like those forms when it comes to this because it doesn't have the option to put anything else in there. So I was trying to put it in that upper hand corner so it was legible.
It's nice and simple for everybody else.
I know, that's why I'm in. So that's what I was saying.
Mhm.
Well, you read this.
What did we get with these? They can change them. Have a little thing somewhere you can notice.
And other.
It's like the TV station. I know which station. Still weird. Get rid of that. Send no. Business.
All right, so. Again, you were looking at a state jail felony, but it is enhanced for punishment purposes as though it were a second degree felony, which is no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. Do you understand? An agreement's been reached where you would be sentenced to 4 years in prison. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand? So how do you plead to paragraph 1, alleging this state jail felony of tampering with electronic monitoring device? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Paragraph 2, this prior conviction alleging on August 9th, 2015 in the 29th District Court of Palo Pinto County, Texas, you were convicted of online solicitation of a minor, second degree felony. Is that true and correct as it is alleged? Yes. And are you pleading true and correct to that voluntarily and because it is true? Yes. And finally, paragraph 3, which alleges that after that online solicitation of a minor, second degree felony, and paragraph 2 was final, you committed another offense of failing to comply with sex offender duty registration and third degree felony. You were finally convicted of that on August 24th, 2021 in the 294th District Court of Van Zandt County, Texas. Is that true and correct as it is alleged? And are you pleading true and correct to that voluntarily and because it is true? All right. Pre-sentence report, Wayne?
Yes, Judge.
All right. If nothing further, I'm going to follow this agreement and find, sir, that you have pleaded guilty to paragraph 1, a state jail felony, and truth to paragraphs 2 and 3, representing prior convictions committed and convicted in sequence, which makes this state jail felony punishable as though it were a second degree felony. And you were looking at no less than 2, no more than 20 years confinement in prison and a fine up to $10,000. That you were pleading guilty voluntarily, knowingly, intelligently. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I'm going to show you what's marked as State's Exhibit 1 is at the top. Is that all true and correct? Did you sign that and understand its contents? State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Also, you need to sign those two counsel for defendant spaces. I'm going to find while he's doing that at the bottom. You are mentally competent based upon State's Exhibit 1, you are mentally competent to enter your pleas in this case. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the bottom to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony and find true beyond a reasonable doubt the prior convictions as alleged in the indictment in sequence in paragraphs 2 and 3, which constitutes 7-degree punishment, 7-degree felony punishment. You are hereby found guilty beyond a reasonable doubt, and you are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened, sir, today?
Yes, sir.
Yes.
Yes, sir.
Anything else to add about the parties?
Nothing but
If not, we're in recess on this case. Edward Porter.